Good morning, everybody. Welcome to Pennsylvanians for Modern Courts One-Day Law School for Journalists. We have over 500 people registered, so there will be people coming in as I'm speaking. PMC was established over 30 years ago after a report from the Pennsylvania Judicial Reform Commission was found an appallingly low level of confidence in Pennsylvania's judicial system arising from the election of judges and the corresponding conflicts from raising monies. PMC was created to advocate for a number of judicial reforms, as well as on behalf of an independent judiciary. We also educate Pennsylvanians about our court system through a series of educational programs, which we bring to community organizations, libraries, and schools on a wide range of topics from civics, court basics, as well as covering specific areas of law such as landlord-tenant, criminal law, family law, estate planning, protection from abuse, in order to help people be more comfortable in the courts and increase access to justice. We have a court watch program where we train observers of arraignments, and PMC has just completed over 250 observations, and we will be issuing a report this fall. And during election years, which are odd-numbered years in Pennsylvania for judicial candidates, PMC hosts candidate forums to showcase the candidates and enable people to make informed decisions about electing their judges. And as you know, we hold these one-day law schools for journalists to help journalists, the press, the media understand the court system on which they're reporting. Lawyers have difficulty understanding the complexities of the legal system and court cases, and they have at least 3 years of training. We hope to provide you with some basic information in order to inform your reporting and give you the tools to ask questions and seek answers. Courts address issues affecting so many aspects of our lives: employment rights, civil rights, family disputes, commercial and business disputes, housing disputes, to name a few. Journalists and reporters are the firewall of our democracy. While judges are limited by their code of conduct from publicly speaking about pending matters in cases and issues before them, you, the press, can shine a light on their decisions and on court proceedings. Both judges and the press hold unique positions among our democratic institutions. The independence of both and the freedom from undue influences are the cornerstone of a democratic society and safeguards for the freedom and rights of the citizens. Both the press and the judiciary faced challenging times during the past 4 years, but nevertheless, I truly believe both institutions are stronger, and as a result have encouraged increased citizen participation and interest in our democracy. We have an amazing program planned today, and over 500 participants have registered. As a result of this interest, all participants will be muted. The program will be recorded. However, we want you to ask questions, so please put them in the chat feature and we will do our best to get to them. You will also be sent a follow-up survey with bios of all the speakers. Your feedback is very much appreciated and used for future programming. We will begin with a conversation with United States District Court Judge for the Eastern District of Pennsylvania, Judge Mark Kearney, followed by a presentation on civil litigation by Professor David Sonenshein, a presentation on civil litigation by myself, a presentation on the Right to Know Act and Open Records by Paula, Knudsen, Burke, and Melewsky, and concluding with a presentation on access to information and the impact of disinformation on the public's confidence in our courts by David Bodney and Arizona Court of Appeals Judge Peter Swann. We will email you the speaker bios, but needless to say, they are very impressive, and we appreciate all of our speakers agreeing to join us today. We are on an extremely tight timeline, so we will keep things moving. And right now, I'd like to welcome Judge Mark Kearney. Your Honor, thank you for joining us. Good morning.
Good morning, Debbie, and good morning to Pennsylvania for Modern Courts. Thank you very much.
So thank you. So I know that you are the 100th judge in the history of the Eastern District of Pennsylvania to be appointed to our bench, and you received a unanimous vote in 2014. I would like to say I think that's pretty rare in this day and age. So I'm excited that you're joining us. And I wanted to know, can you share with us just a little bit of your personal background? Like, what did you do before you became a judge? Why did you become a judge?
Sure, Deb. And again, thank you and welcome. And I'm certainly open to answering any questions. That'll be sort of the theme of what I'm going to talk about today. I think there's a real dialogue that we can start. So I was a practicing lawyer. I was born and raised outside of Philadelphia, born in Philadelphia and raised outside of Philadelphia. Attended schools in the Philadelphia area, graduated law school and received a clerkship. And I received a clerkship in a court known as the Delaware Court of Chancery. Everybody on this line today now knows the Delaware Court of Chancery because of Mr. Musk and the Twitter dispute. And I get a kick out of it. There was a Venn diagram the other day, you may have seen, where it had a big circle and it said, everybody who knows something about Musk and first Twitter, and then a little circle says, anybody who knows anything about the Delaware Court of Chancery. So the Delaware Court of Chancery was the court that I clerked in after graduating from law school. And I had the great, I was there in the mid 80s with the takeover world, poison pills, et cetera, like that. My first case, Deb, actually my second case, third day on the court, I walk into the room and before me at one table, now in the Chancery Court, you're about 5 feet away from the litigants because there's no jury. On one table was the future president of the United States, Donald J. Trump. And on the other table was the great entertainer and talk show host, Merv Griffin. And they were literally 5 feet away from me. And I'm thinking there, what kind of job do I walk into? But what was interesting about the press there is those of you who know the financial press follow the Delaware Court of Chancery religiously. I mean, they have Delaware Business Court Insider. They have all kinds of press there. And we were trained from very young lawyers and Chancery lawyers not to speak at all. We had to be very careful because obviously a slip from us in the court could result in massive financial maneuverings in the market. And so we learned very early not to do that. I then had the opportunity to practice both in Wilmington and Philadelphia for about 25 years. I came to understand there was an opportunity to seek a position in the United States District Court. I had been very involved in the federal courts as a lawyer. My practice was almost always in Chancery Court or the federal courts. And then I applied. That system, by the way, those of you who don't know, that's a system where lawyers or the senators of each home state send out an announcement saying anybody interested. And literally, I think, particularly like Pennsylvania, you get hundreds and hundreds of applicants. And then the senators have a team that screen them. And then certain persons, about 50 or 60 or so, are invited to meet with a group of lawyers. And then those lawyers recommend certain persons to the senators. The senators then do a complete vetting process. I was nominated by President Obama. President Obama is colloquially referred to, was then anyway, at DOJ, as no drama Obama. There was an investigation before I was nominated where the FBI visited 900 of my acquaintances, I guess, people who knew me, and they asked them all the same question: what can you tell us bad about him? So you get through that process, and then you go to the United States Senate. You get nominated by the president. The president does not nominate you until you're already through that process. I think the press doesn't quite understand that because I think they're used to seeing the Supreme Court, and they see the people go there. The reality is those people are completely vetted. We're completely vetted before we get there. But the United States Senate has its own play under the Constitution. They have a right to advise and consent, and they then do an investigation. The investigation that the United States Senate does is not to the same extent as the FBI and the Department of Justice in the White House. So you do that process, and Debbie's right that you're usually packaged in a group of certain people. There's 3 or 4 people. And so I was packaged with 3 other people in Pennsylvania, and we were nominated. And yesterday, 8 years ago, was the day I appeared for the United States Senate. Yesterday was the 8th anniversary of my appearing in the United States Senate. And the same table that Justice Jackson just sat at, the same table that Justice Ginsburg, everyone else sat at, and we get asked different questions. They're not asking us the same questions. But I'm always amazed, since the Trump administration, this has been religiously followed. The only person in my confirmation hearing was roll call, which is a Capitol Hill paper publication, I guess, then at least a paper publication. And they followed along. And so virtually no one else followed along. Even the local Philadelphia papers or Pennsylvania papers didn't follow along. The only thing they announced is the nomination, and they go from there. And they basically take it from our lawyers' websites. And so that's a long way of answering your question, Deb, but that gets you up to where.
But that's interesting, the change in even an 8-year period of time where you had no press, and now, and now it's even on live stream TV.
Yes.
So it's quite a change.
Yes. We were on live. We were on not live stream, but we were on a. You had to link into the United States Senate and be a magician with the computer to figure out how to get into the United States Senate feed. So your aunt and your uncle could find you, but really nobody else could find you.
So you go through this confirmation process, you're confirmed. And now how do you learn about how to be a judge?
Well, that's a great question, because many of us, not me, but many of us were state court judges before. So they have some flavor, but the systems are entirely different. I don't think what the world understands is the federal system is so much different than the state system. It's an entirely different government. I hate to say it that broadly, but it's an entirely different government. And so we do things much differently than they do in the state system. So some members of our court come from the state court. They still have the same lessons I have to learn. I, in some sense, had it easier because I practiced in federal court. I knew all the language. I knew the lingo. I knew the judges. So what they do is they send you out to something called baby judge school. It's a cute term. And you go for a couple weeks, 1 week, and then you come back for a second week, and then you have other sessions thereafter. And they sort of teach you. Little inside baseball here. Judges are generalists in the federal court. I don't think the press understands that. I think they think, oh, they come to Judge Kearney and he's going to be the expert on all types of things. That's just not possible. So what happens is we have to learn each case new. And, while I practiced in an area, Chancery Court, corporate litigation, I understood that. I come down here and the first couple of cases I get are immigration cases.
Right.
So they teach you, and then you get a patent case, and then you get a child being taken to Belgium, right? And the United States treaties. This is something that nowhere could you learn. And so they don't teach you in baby judge school the law. They teach you how to deal with the system. And one of those things is how to deal with the idea of educating the public. Okay.
So I'm curious. So you've been, a judge now for 8 years. Any particular trial ever surprised you? Surprised you maybe in its outcome or how it's proceeded, or even that it made its way to federal court?
Yeah, that's a great question. So federal criminal law is interesting because the federal prosecutors don't have to take a lot of cases. I think everybody thinks that the federal prosecutors have a great amount of discretion. So sometimes you'll get a case, like I'm trying one in August, a very interesting case, a criminal case, starting August 15th, that you think, why is this in federal court? It's a harassment case of estranged spouses, one in Russia and the victim spouse, allegedly, from the Ukraine. Now, obviously the timing's unique, right? But the United States, as the prosecutor, chooses its cases. So you get a lot of unique cases. Yes, you get so just a little insight, only about 10% of our docket is criminal. That's something I don't think the world understands.
No, I thought it was larger than that, actually.
No, the criminal docket is largely in state court because that's your local crimes, right? The framers across the street from my courthouse in 1789 separated out those folks who they didn't want to impinge on local politics and local play. So they let all the state crimes stay in state court. To get in the federal court, you have to have an interstate nexus. It has to be a crime that in some way crosses the lines of a state. So that's a lot. Most drug sales, unless you're growing the drug in your backyard and selling it in your backyard and not getting any money for it, it's hard not to have an interstate nexus. So interesting cases, sure. You see them, almost all of them are new to us all the time. I think that people think, oh, the judge sees this all the time. No, at 9:30, I'm going to see something today I've never seen before. I spent last night just studying this issue because I've never seen the issue before. And so one of the interesting things that came up to me is I was a baby judge, and I was a subject of a very complicated press issue about the ability to film police officers doing their work. And the law in the United States then, this is 2015, the law in the United States then was that the police officers could take citizens' cameras, phone cameras, in order they were interfering with the investigation. You know, they didn't want citizens, everybody armed as a press, which is terrific, by the way. Everybody agreed it's terrific. And where would we be as a society without cameras?
Without cameras, yeah.
Yeah, okay. But the law had not caught up. And I think that's something the press to understand. The law had not caught up. The law is a lagging indicator. Right? I mean, you know, the United States Supreme Court issues a ruling. It is after years and years and years of fermentation. When a case got to me about cameras, every instinct in our body was that, wait a second, you have to be able to take photos. I mean, this is crazy. But the law was that at that time, you really couldn't. And the police could act, as long as they acted reasonably, they could do so. Well, you know, that set up a maelstrom. And I'm a baby judge, and all of a sudden I'm on the Fox News, and I have death threats and everything else. And I'm thinking, I just applied the law. What the world doesn't understand is that judges our society is based on an orderly precedent.
Right.
And if I don't follow if Judge Kearney just makes it up, people have no confidence in our judiciary. I could have made it up. I mean, my gut told me this is wrong, but that's not the oath I took. My oath is to follow the law. And until my Court of Appeals and the Pennsylvania United States Supreme Court rule, I have to follow that rule of law.
So you have limitations as a judge. Many limitations as a judge, but one of which you just discussed, which is following the rule of law. But what other limitations do you have? Because I know that even speaking, right, you have certain limitations. Sure.
I mean, I don't go to any private enterprises. Like, I won't go to a company event and speak. You know, because I'm sitting here impartial. I'll speak to something like you because you're a nonprofit. You cross all spectrums. You know, so let's be very candid with each other. The people that get elected, get appointed to be a federal judge, must know other people. I mean, 900 people were visited from me. Now, the senators who nominate you know thousands and thousands and thousands of people by name, or their aides help them. And so you know these people, and you know them because you're involved in the process. I mean, I don't care who you are as a judge, you must have known somebody who knew somebody, because he's just, you know, the president is not going to pick a complete stranger. Well,
you practiced law before, you litigated against and with many lawyers, right? So
right. Right. But my point is, so when you're a lawyer, you show up at every political event in the world. That's your part of your talent. Your part of your talent is being out there and supporting everybody. The minute you take that oath, in fact, Deb, I was in a hearing on the day I got the call from the United States Senate that you're up for nomination. Your vote's coming up. I was in a hearing, and I was supposed to go that night and do a fundraiser, like be a co-host of a fundraiser. I was told in very certain terms, you are to get off the podium, and you are not to do anything tonight. And that stopped my world. So, for instance, I don't contribute to candidates. I don't speak about political issues. Judges don't speak extemporaneously, in the sense that we don't go out and give a speech about an issue. The only exception to that, of course, that I can think of is Judge John Jones, who, after the case concerning evolution in Pennsylvania, went out long after it was done, went out and gave some stories about the significance of the case. I do the same thing. I'll talk about cases I addressed 3 or 4 years ago, but not when I'm in the middle of it. I just can't. I'm not allowed to.
Right. So, you know, so I know that you have a strong passion for civics education, right?
Yes.
So what do you? I mean, so that's speaking, okay. But you know, what are you communicating to high school students, about the courts?
Yeah, let's be very clear that our civics education is everybody seems to understand high school mock trial, and that's something that everybody gets, but that's a very small portion of what we do. What we're really doing, and this is something set up those of you who are familiar with it, a couple summers ago, Justice Breyer, Justice Kagan, Chief Justice Roberts, Justice Alito, Justice Kavanaugh, Justice Gorsuch, they all came out with different speeches about the independent judiciary and having to be in the public, because there was such a disinformation campaign. There was such a campaign to characterize public judges as a Bush judge or an Obama judge or a Trump judge. And the reality is that the second week I was here, Deb, the second week I was here, I put my pen to a piece of paper and stopped. The defendant is Barack H. Obama, right? He's just the defendant because in his title, right? So I'm signing an order enjoining Barack Obama from doing something. And I'm thinking, they must not think I'm a very nice person. You know, thank you for that job 2 weeks ago. So you have to sort of drop all that. And so you have to go out and tell the public that. So we do it at grade school. We do a 5th and 6th grade contest that I think the press covered fantastically, by the way, back this past May. We do a high school mock. We're doing something really unique this year, Deb. We're bringing those students on the line. We're bringing a criminal sentencing exercise, mock exercise to college crim justice, psych, social work, pre-law majors. In fact, today, my colleagues and I are going onto a YouTube channel and doing a mock sentencing exercise. It's going to be available to all the colleges and universities across the Commonwealth. And we're going to open it up to them and invite them into the federal courts to do a mock sentencing exercise. We do adult education, all the community colleges. We go to the community colleges and speak. We go on appropriate, like bar associations and Pennsylvanians for Modern Courts, where we can tell people, hey, look, and I just got back from a big event in Pennsylvania, not far from where you, I know Debbie was out in Erie a couple weeks ago, and I was in Seven Springs, Pennsylvania, Western Pennsylvania, talking all about this issue, saying, look, we've got to get the word out that the people who are deciding these cases are not held to any type of political or other relationship, despite what happened in the June term of the United States Supreme Court, despite what everybody thinks happened.
Right. Okay. So the federal courts right now don't allow, cameras and recordings in the courtroom. So how can the press cover, a newsworthy matter?
Okay, so there are, and I urge anybody who's a student who wants to know this, is to get in contact with Debbie or get in contact with me, and we'll bring judges in to talk to your journalism classes. Because I think what's happening is that you show up and it's the middle of a trial day, and there's a lot of testimony that just drones on, and you're like, what am I going to write about this? Person's talking about some documents they got from a bank. What am I going to talk about that for? The problem is we don't give press releases, right? We don't have press conferences. So when we have to get the word out, the press kind of says the word, hey, there's a big trial. The press is interested, I get it. The press is interested in trials involving public figures. But what happens all the time is that there's a great amount of interest in cases that affect everyday life. And there used to be, and Deb, I'm sure remembers this, even 20 years ago, there was a press office in our building where people would work here every day. There'd be members of the local papers who work every day, the legal paper, the mass media papers, and they would work here and they would report on what's going on in the courts. That's not economically feasible at this stage. So they rely on us in some sense to feed them information, but we can't feed it live. I mean, we don't have CNN breaking news. We don't, Judge Kearney takes the bench. I mean, that doesn't happen the way you would hope it may. In some states it does, but not in the federal, at least most federal courts doesn't happen.
Have you ever permitted cameras in the courtroom?
No.
I mean, I know there could be if somebody makes a request,
right,
it could be considered, I'll say.
Yeah, let me say this to you. There's a lot of efforts in legislation, et cetera, to do so. Here's the problem. And I'm going to be a little bit on my soapbox here. But federal judges' names and addresses, you can go into Google and get a picture of my house. Yeah. Our security is a great risk. And I don't think people understand that. And that's okay. There's a bill, the Senate 2 years ago, last week, the murder of Judge Esther Salas. But that's just, and by the way, she was the first of 6 female judges that was on that list. So what the concern is we don't want to become, and no disrespect to the monopoly that Judge Judy has created, but we don't want to create We don't want to create something where people feel that comfortable in showing up at my house. And so there's this view. And second, we don't want any technology in the courtroom that can be used as some kind of explosive device. That has happened across the United States, where people have brought in various types of cameras or types of recording machines that they get next to the judge and testify, and it blows up.
Wow.
So
yeah, I remember years ago. I mean, I think now in the courthouse, people can bring their cell phones, right? But years ago, we couldn't even bring our cell phones into the courthouse.
Well, that's in this courthouse, you still can't. You have to get. They take your cell phone unless you're a member of the bar.
Okay.
So that for that very reason, because they're afraid of explosive devices in the cell phone.
So have you had any trials that the press are in the courtroom, and how do you handle that?
Yeah, you don't. I mean, it's kind of funny. It's like athletes talk about a game, you don't know sometimes the press. Yes, you know them there. Your deputy comes in and says, hey, by the way, 3 or 4 reporters asked me about the hearing today. You just have to do your job. And once you recognize they're there, what I wish would happen more, Deb, and I urge all journalists to think about this. I wish what would happen more is that journalists would ask the deputies what's going on. The deputies are very talented people. These are not in the federal courts. These are, I don't know about state courts, I don't speak for them, but in the federal system, these are enormously talented people, postdoctorate graduates. These are people that understand how the world works, and they can explain it in a way that may be helpful. Here's how I communicate. A little side story. When I was baby judge school, I sat with Justice Scalia at my table, and he turned to me and said, who are your children? At that time, I had a 7th grade daughter, and I showed him a picture on my phone. It's my daughter. And he picks up my phone and shows every judge around the table, 10 of us. He says, from now on, you write to Mary. My daughter's name. You write to Mary. And it was a great lesson. I've never forgot it. That we're writing at least in the first 250 words, or 500 words, we're trying to write to the 7th grader. We're trying to say, this is what's going on. Now, many of my colleagues weren't trained that way, but I would say since the 2010 judges in the last 12 years, if you look at our opinions, you look at the Supreme Court's opinions, by the way, they're largely written so you can at least get a grasp up front what's going on. That's the way.
And that's important. I mean, because the opinions used to be written, right, for the parties who are litigating, but sometimes it could be complex business matters, and the public might not necessarily be able to understand them. I mean, I know that some judges issue opinions that are greater than 100 pages.
Yeah.
Who has time to go through that?
A couple months ago, guys, I had a case where a gentleman in the 60s and 70s went out and stole all these artifacts from the American Revolution. And he literally walked into various museums and stole them. And he took them home. And he held them in his garage for 40 years. It became a big cause célèbre. In fact, I don't know if I can say this publicly, but one of the big celebrities who has a production company bought the rights to his story and is going to do a movie. So I don't think they're not going to get to me, but
they're not
you know what I
you.
mean? Not yet. Yeah. So, but what I'm getting at is the press was packed in that courtroom because it had a great human interest. An 80-year-old man confesses to stealing things that were worth millions of dollars.
And 40 years ago. So he's confessing to something that occurred 40 years ago. Wow.
Yeah.
So we're almost up with our time. So I just wanted to know if there's anything that, feel free. You are on a soapbox, but we very much appreciate it. And, if you want to tell the attendees about covering covering judges, federal court, anything.
I think, thank you, Deb, first for the opportunity, and thank you all for your attention. I think the main thing that I hope journalists will understand is that we are taught to write like you are taught to write. That is so different than what lawyers write. I hate to be that way, but lawyers are taught to be advocates. And sometimes, sometimes the details that are not good for them are not up front. They're somewhere in the middle. We are taught in the first 150 to 200 words to tell the story the way you would. This is what's going on. And I think one thing I'd urge you is if you have an opportunity to bring judges into your courtroom, particularly in Pennsylvania, I can't speak for, and in the Third Circuit, which is Pennsylvania, New Jersey, and Delaware, and the Virgin Islands. But if we can be helpful, we'd like to be. The second thing I would say is if you have a question, I can't answer it. I can't get on the phone with you and explain it to you. But I would really urge you to call the lawyers for two reasons. One, the lawyers know we're going to read it and they're going to be pretty careful about what they say. But second, because in their interest, they want to get the word out too. Maybe for marketing reasons, maybe for whatever reason they have, but they're out there. And I think if you don't understand what's being written in the opinion, if the judge doesn't make it clear to you, then call them. I think I just got a chat message there, Deb. Oh,
sorry. Okay. Judge Kearney, could you elaborate on what baby judge school is?
Yeah. It's you go to a town.
And who runs it? And the federal court system runs it, right? The United States court system. Yeah.
United States, the Federal Judicial Center, which is the educational arm of the federal court system, out of Washington, and they take everybody that was sort of confirmed within a period of time. So maybe when I was confirmed, there was 46 of us that were confirmed in that 6-month period, and 46 of us go someplace.
And it's not only it's district judges, circuit court judges. Yeah. Right, it's all new federal judges.
Yeah, not Supremes, but
not Supreme, right?
Yeah, but district court judges and circuit court judges go somewhere, and we have sessions that are just like what the college students are going through. We start at 8:30. We start at 8:30. We go to about 4:30. We have a nice dinner. We go back and study at night, and then we come back in the next morning. And so it's 5 days, and then and then there's another 5 days. Then you go to other sessions, and I have to go back. I'm not required, but I'm urged to go back, and I go back every couple of years. Now, the pandemic, several of us missed our cycles, but I'll be going back in a couple of months.
Okay, last question. It says, can federal judges control COVID protocols in their own courtrooms? Proof of vaccination. Yeah,
it's a great question. It depends court by court. It depends where you are. Remember, we are governed by, in that sense, city and state governments. When we were in Philadelphia, we were controlled by what Philadelphia said. I also sit, by the way, in Pittsburgh, and I sit in Wilmington. So I have different rules in Pittsburgh and Wilmington than I sit in Philadelphia. But in our courtrooms, yes, in the rooms themselves, we do it. Now, a friend of mine is a judge in Philadelphia. He's still in state court. They're still masking everybody in his courtroom. But we're not. I just had a trial a couple weeks ago. Nobody was wearing masks. But it depends on what the county and city and state you're in.
Can the lawyers request it if maybe there's a witness that has some vulnerabilities, or and you make a motion before you?
Well, I haven't had it happen to me, but I've heard of it. The problem is this. That if a witness is at a vulnerability, we will typically put them on video. Because the concern is that nobody's going to be comfortable enough. And look, the jury comes, we're a big district. We have 9 counties. People drive 2.5 hours. People from Lancaster County or Northampton County in Pennsylvania, which are far-flung counties, have much different views about COVID than people in other counties. And so you can't put 8 people or 12 people in a box and say, by the way, sit next to that person. That person hasn't got vaccinated. So we have asked that question if you're uncomfortable. But we never stopped. I mean, we only stopped there. This is interesting. We only stopped impaneling juries. My first jury trial was in July of 2020. So if your mind can go back, that's about
March, right?
Yeah. So we stopped a bit. I mean, we went on and off, but we never stopped. We did a lot of this. I heard a lot of witnesses the way I'm seeing you now. We heard a lot, and it worked fantastic. By the way, that's a great question. I want to finish with this. Every order we enter has if it's a Zoom link, it has a Zoom link on it, and because we're a public hearing. So let's assume you're a reporter, and it happens all the time. The Wall Street Journal was following me on a big case in Delaware, and they were on every single hearing because they don't have to drive to Philadelphia or Wilmington.
Right.
And so if you see a clip, you can ask if it's going on Zoom, and you can get on. You're a member of the public, and you can sit in your kitchen and participate in the hearing.
No, I think I say there's always a silver lining for COVID, and it's that we can get into the courtroom easier. We can speak to people across the state easier, so. Well, I want to thank you so much for your time. I really appreciate it. And I know there's a lot of questions. Hopefully some of the questions we'll get to in some of the other programs, but thank you, Your Honor, and good luck with your day.
Thank you very much, everybody. Have a great day.
Thanks.
Thank you.
Okay, so next, and we're already running late, so I'm going to keep us moving. We have Professor David Sonenshein speaking to us about what you should know about criminal law. So 101, I say. So thank you, David.
Thank you, Debbie. I'm delighted to see you all today. I've been looking forward to this presentation. I usually present to lawyers, to law students, obviously for 40 years, and to judges. By the way, Judge Kearney mentioned baby judges school. I've taught a baby judges school about 15 or 20 times over the years. And I have to say they are the very, very best audience I've ever had because this is their bread and butter. And I teach evidence and they really want to get it right. And I just want to say one thing because Judge Kearney was here. Whatever you read about appeals court judges and Supreme Court judges and their political inclinations and all of that kind of thing, my experience with federal district judges over many, many years is irrespective of who appointed them. They by and large just want to get it right and give both sides a fair shot at making their cases. That to me is pretty universal for federal trial judges. And Judge Kearney is certainly one of those judges. And it's something I think you can appreciate. And as a citizen, I frankly appreciate. Okay, we're going to talk about criminal litigation. And as Judge Kearney suggested, we have two very different systems in the United States, state and federal. And you understand we are unique. I teach a lot in Europe, and nowhere in continental Europe do you have state courts versus federal courts. This is rather unique to the United States. And so there are great differences between and among various state courts. The federal courts, of course, are universal in that they all apply the same federal rules of civil procedure, the federal rules of criminal procedure, and of course, everybody's governed by the US Supreme Court and the circuit within which the federal district court sits. In the Philadelphia, of course, that includes the Third Circuit. But before I get into the actual items of litigation, let me just say a couple of things you want to keep in mind. Contrary to what you see on television and Law and Order and everywhere else, the vast majority of criminal cases and civil cases, by the way, as Debbie will attest in a little while, are resolved without a trial. I get annually the report from the Federal Judicial Center, which reports on the number of trials in federal courts throughout the country. And there are numbers of federal circuits where the percentage of cases that go to trial is under 1%. I'm talking about a percentage of 1%. And there are numbers of states, I remember looking at Florida, where the percentage of cases, civil cases going to trial in Florida was, you had to go 3 decimal points out to get to a number after the decimal point, to find a number for the percentage of cases in Florida that go to trial. It's very, very similar in criminal cases. The vast majority of criminal cases in the United States are determined pre-trial, more often than not by guilty pleas. And we're talking about in the federal and state system, by and large, 2 or 3% of cases actually end up in a trial, and some smaller number of that end up in a jury trial. So the popular notion that you see on television would give you the impression that every case goes to trial and, you know, the clash of titans and all that stuff is Hollywood. It does happen. There was a time when I was practicing in Boston about 40 years ago when I'm told that 30% of cases went to trial. That is certainly not the case anymore. So bear that in mind. The cases going to trial are a tiny percentage of the cases filed both criminally and civilly in the United States. Number one. And indeed, in misdemeanor cases, in the smaller cases, you will find that, in fact, many of those cases are resolved at arraignment, at the very first appearance. That is before anything has really happened. And there's been a deal worked out between the public defender or the private counsel and the prosecutor at the time of the arraignment of the defendant. And at that moment, the case is over. And so people don't realize that. We don't see those cases, obviously, on television or in the movies. Couple of other points to keep in mind. The vast majority of people who are charged with crimes are, in fact, guilty of at least one of the crimes with which they're charged. Okay. That said, and I want to be clear, we're press people, get the whole statement. That said, an uncomfortable number of people are convicted who are factually innocent. Okay. That is a fact. No one can dispute. At the moment in the United States, over the last 15 years, 3,000 people who were innocent, that is factually innocent, have been exonerated, most of them from the most serious crimes, murder, things of that nature, and many were on death row. So be aware of that. And what I will tell you is, from my experience, and I'll just make full disclosure here, I'm not only on the board of Pennsylvania for Modern Courts, but I'm on the board of the Pennsylvania Innocence Project. So I'm very familiar with the statistics. We have found that the vast majority of those wrongful convictions were avoidable. They're not
David, I'm just going to
accidental.
interrupt you for 1 minute.
Yeah.
Sorry about that. But the Pennsylvania Innocence Project is just one state. I mean, the Innocence Project is in many other states as well, right?
Correct. There's a project in almost every jurisdiction, every state, and there's the national project which is based in New York out of Cardozo Law School. That's correct. So in most of the places you are, there is an Innocence Project. So just be aware of that. But we have found most of those convictions, if not all, or almost all, were avoidable. There was a mistake made, usually on the prosecutorial side, sometimes inadvertent, obviously. But the fact is, almost all of them are avoidable. And one of the big problems that was avoidable was ineffective assistance of counsel. So let's not exonerate the lawyers here, although I am a lawyer and trained lawyers and have for many years. One other point that goes with this, people do make false confessions. And I never believed that till I started seeing the cases. They do. They do, and police will confirm that, and so will prosecutors. And then finally forensics, which we've always thought is, you see it on television, on CSI, and you see it on the British procedural shows, and it looks like there's super science going on, and often there is. But forensics have been wrong. DNA is not wrong. DNA is the gold standard, both for conviction and for exoneration. Bear that in mind. No one really challenges DNA. It really is. But other items, bite marks have now been abandoned by the FBI and other people. It's a bogus science. There is no science of bite marks. Hair comparison. Arson evidence has undergone a tremendous change over the last 15 or 20 years. And a lot of people were convicted of arson based on faulty arson evidence by experts. Arson experts who have now changed the way they look at these things. Even fingerprints, frankly, have been questioned as to whether there's really a scientific basis and a real agreement among scientists about how many comparisons or how many comparisons are required before you can say some of these fingerprints are legit. So bear those things in mind. A lot of these are, in the popular world, sort of counterintuitive. And that's why I mentioned them to you, just so you're aware of these things in terms of the folks for whom you're writing. Judges in our system who hear criminal cases in the federal system, as Judge Kearney just said, are appointed by the president. And most of those, almost all, have been pretty long practice careers. State court judges in a fair number of states, not all states, but a fair number of states, are elected in partisan elections. And I practiced in Massachusetts, where judges were appointed by the governor, who had three choices from a blue ribbon panel. Couldn't appoint a friend or a colleague, had to pick one of the three from a group of law school deans who gave him the list or her the list. And that to me is equivalent, well, it's probably even more significant than the president appointing, quite frankly. But in other states, they're elected and run for office and in fact can collect campaign contributions, Pennsylvania being one of those states. I will tell you that one of the downsides of that, and you must appreciate that when you're covering sometimes, not in every case, there are plenty of good state court judges, obviously, and experienced ones. I remember when I lived in Chicago, when I first got there and I was teaching there, I saw a political ad by a judge running against a person running against a sitting judge. And the ad attacked the sitting judge for writing an opinion that suppressed evidence in a case. Okay, and the ad said Judge X is freeing, drug dealer or whatever it was. Well, that looks pretty scary to a layperson, right? Well, in fact, the judge was part of a 7-0 vote on a panel made up of Democrats and Republicans, right? Who saw a clear constitutional violation and did what they had to do according to their oath. Now, how do you get that across to voters, right? Once you see this horrifying ad. So I have real concerns often about that situation, but that's a matter of state constitution in every state. Interestingly, in the criminal state system, prosecutors are mostly elected, which again means they are political actors. In the federal courts, they are appointed by the president. Is there some politics involved in who becomes the U.S. attorney? Of course, we're not Pollyannish here, but generally speaking, you don't really concern yourself very much with those kinds of issues with federal prosecutors. One key thing for both kinds of prosecutors that people don't necessarily realize, they have essentially absolute and unbridled discretion in terms of the cases they choose to bring. In Europe, that is not true. There is mandatory prosecution for a European prosecutor. If you have evidence of a crime, you must prosecute. Okay, that is unknown in the United States. The fact that a case is brought is because a prosecutor has made a conscious decision. I choose to bring this case. I could bring other cases. I choose not to. So your prosecutors are very, very important people. Not only in the sense that they are prosecuting, people who are charged with crimes, but in terms of even deciding whom to charge. And they have, again, a discretion which is essentially unreviewable. They have immunity in those decisions. And so their power is really, in a sense, unbridled, except if you're running for re-election, or they're going to be removed by the president if you're a federal prosecutor, or by the attorney general. In the federal system, people are charged by a grand jury indictment. In many states as well. In fact, in 48 states, that is done. You see it in Law and Order in New York. New York is a state that has grand juries for felonies, as do the federal courts. Some states do not have active grand juries in that way. There are two, traditionally, Connecticut and Pennsylvania. Pennsylvania has investigating grand juries, but traditionally, there is some issue now, traditionally they have operated by simply a complaint, or an information filed by a county prosecutor. But again, we shouldn't get too excited about the grand jury system. I think every lawyer you ever meet will give you this famous aphorism about grand juries, and that is a grand jury will indict a ham sandwich if asked to by a federal prosecutor or a state prosecutor. Grand jurors were there theoretically to protect us from the crown back in the 18th century, but I think everybody knows they're getting an ex parte, one side view of a case. And in fairness to them, it's pretty hard not to indict when you're getting only one side of the case. So grand juries very, very often will indict, or more often than almost always will indict when asked to by a prosecutor. Who are the defense counsel? As you know, back in 1966, the Supreme Court decided that every American who's being tried for a crime which carries at least 6 months in jail is entitled to a lawyer. It may surprise you to know that prior to that time, most criminal defendants in the United States appeared without a lawyer. It sounds astounding when you think about it, right? But that was true, including in serious cases, and it was left to the discretion of local judges. And when you think about it, since we have an adversary system, again, US, Britain, a couple of other former British colonies have the adversary system, which is based on a clash of equal opponents, right? When you think about it, it's hard to believe that for the first 200 years in the United States, large numbers of people went to trial by themselves against the government. Well, happily, those days are now over. So who are the defense lawyers? Well, obviously, if you're wealthy or wealthy enough, you hire private counsel, who is going to be usually quite expensive, and often is often, by the way, just so you know, in federal cases, usually a former federal prosecutor. Anytime you watch TV, you watch the hearings last week. I'm looking at the hearings and I'm looking at the lawyers sitting behind the witnesses in front of the House Congressional Committee. And I'm saying to my wife, former U.S. attorney, former U.S. attorney, former U.S. attorney, because those are the people who you'll see in the white collar kinds of cases. Nothing illegitimate about that. That's just the way it is. But most people don't get private, expensive counsel. Most people, middle-class people, cannot afford, the former U.S. attorney to represent them, or a former U.S. attorney. Wealthier people, doctors, lawyers, business people who have a lot at stake can often do that. The public defender service in every jurisdiction, or most jurisdictions, handles most people who can't afford a lawyer. But there are situations where, in fact, the court will have to appoint a lawyer from a list the court maintains, or in point of fact, from the court's own desires to represent somebody. And the problem with private lawyers appointed by courts is very simple. They pay them a pathetic amount of money. And those people have very, very few resources to work with. Less, frankly, than the public defender services do. And so that's a real problem. That's a real problem in terms of the defense that you get from people. And I have plenty of friends of mine who've done wonderful jobs as appointed counsel. I'm not suggesting they're all doing a bad job, but they have very, very limited resources. And that has become a problem in the United States. Okay, let's turn to the litigation system itself. What, again, many people don't appreciate is the pre-trial segment of criminal practice. Again, you are not called in usually to view a motion to suppress evidence. Those are not, they're public, but you're not often going to be covering that. It's very early in the case, but often it is the determining factor in the case. And motion to suppress generally involve three different issues. One is a motion to suppress a confession obtained by the police. The second is a motion to suppress the fruit of a search and seizure, which includes a wiretap, by the way, which it's alleged by the defendant or defense counsel was obtained without probable cause or without a warrant. And third, that in fact a lineup or identification procedure conducted by the police, and we're all familiar with lineups, and 6 people, off half of them are usually police officers pulled in from one of the desks, standing in a line in a two-way mirror with little heights above them, 5'11", 6 feet, 6'1", whatever. And those situations, and those sometimes lead to misidentifications because of errors in the way those are handled. And all of these issues are often, very, very often, the determining factor in criminal litigation. That is to say, a criminal defendant believes his or her confession was illegally obtained through coercion, violation of Miranda, etc. Files a motion to suppress the evidence. This is early on in the case, in the first couple of months, okay? Asking the trial judge to throw the confession out, which the Supreme Court has authorized, when in fact the confession was in fact coerced, or in violation of the procedural warnings, which is also coercive, by the way, those absence of warnings under Miranda. If the judge throws the confession out, it may well be that the case may be over, because that may be the only legitimate or serious evidence the government has. Now, a good prosecutor will tell you, and I've heard them say this dozens of times, I don't want to go to court for trial with simply a confession and nothing else. I want some real evidence. I want some other corroborating evidence, because I don't necessarily know, A, that the confession is accurate, and B, that it will be believed, okay? But if the confession is kicked out of the case may legally go on if there's sufficient other evidence, but sometimes it will not, because the government says, look, without the confession, since we don't have an eyewitness, they don't have fingerprints, we don't have DNA, we don't have much to go on, then the case may effectively end. Same thing with lineups. if there's an identification which a district judge or a state court judge excludes, says, I'm sorry, that lineup procedure was completely suggestive. It essentially isolated in one way or another the suspect, and in every way, sort of as if you have arrows pointing at number 4 in the lineup. I'm being metaphorical, of course, okay? And if that happens very often, that could be the end of a prosecution. Again, there may be other people that make a good identification. There may be plenty of other evidence, and the case may go on. But it will go on without that identification being permitted to be described, either the out-of-court identification in the police station, or we won't have that witness stand up in court and say, that's the guy, I'll never forget his face, right? Now, the other item that we'll talk about is search and seizure. And that's probably the largest number of motions to suppress you will hear about. And of course, in a case where the possession is the crime, drug cases, right? Whether it's simple possession or possession with intent to distribute, which is often determined by a number of things, including the amount of drugs in your possession, right? If that evidence is suppressed, that case is over, okay? If that evidence is suppressed, the case is over because there's no evidence of the crime, the stuff that was possessed at all. And so that is, of these 3 situations, that is the motion to suppress that effectively always ends a prosecution, okay? Now, why would a search and seizure, the product of a search and seizure, be suppressed? A couple of reasons. One, there was not probable cause, okay, which is the constitutional standard which the police and a court must apply to decide whether the search was valid under the 4th Amendment. Probable cause, very tricky concept, never been in 250 years, never perfectly defined. We do know a couple of things. It is unquestionably a much lower standard than beyond a reasonable doubt. Okay, we know that. We also know it is less than 51%, the civil standard. It is less than by a preponderance of the evidence. What it really is what a reasonable, well-trained police officer, right, looking at these facts, could we, looking now in retrospect, say that officer really reasonable thinking crime was committed and committed by this person? It's really a reasonable standard, which, as you may know, in the law permeates the law. It permeates civil practice as well as criminal practice. Okay, so 1, was there probable cause? 2, was there a warrant? Because the warrant requirement, going way back to 1780s and 90s, right, was put in to make sure that a neutral third party, a judge, a magistrate, stands between the citizen and the government to decide was there probable cause or not before the search or before the arrest, okay? And the idea is that that judge, magistrate, whoever it might be, will look at this and say, you know what? I don't think there's enough here. If you have more evidence, come back. But otherwise, I'm not going to give you the warrant, and you cannot make the arrest or cannot conduct the search. Okay? And so the warrant requirement, however, has many, many exceptions. And a number of them, some people will say the exceptions almost swallow the rule in some situations. For example, the US Supreme Court says if you stop somebody with probable cause to stop or make an arrest or to search in an automobile, there's no need for a warrant. The theory originally was because the person could flee in the automobile. It's been expanded now to say almost. Is there a car involved? You don't need a warrant. Now, interestingly, very important point for you to appreciate, and this is a good example. That's what the Supreme Court has said, okay? Certainly that applies in federal courts. It also applies in state courts, although states are free to provide a higher standard of constitutional protection under their own constitutions. We're seeing a lot of this recently, the last 15, 20 years. So in Pennsylvania, for example, the Supreme Court of Pennsylvania has ruled that when you're making an arrest or a search of a car, you do need a warrant. absent some exigent circumstance, that there's a real likelihood there's going to be somebody fleeing or evidence destroyed or whatever. In other words, the Pennsylvania Constitution has been held to provide more protection to the citizen than the US Constitution. And interestingly, and this is just a fact that any lawyer will tell you, since the US Supreme Court became very, very conservative, particularly in terms of constitutional protections for criminal suspects, many, many lawyers have brought up the state constitution. So when they challenge and bring a motion to suppress a search or a confession or a lineup, they will say, let me look at the Pennsylvania Constitution, let me look at the Tennessee Constitution. And the court may apply that as well and say, yeah, quite frankly, under our Constitution, that's a bad search. And this case and the product of the search will be suppressed. This is a very large movement all over the United States because we're finding, even in states that you might even consider conservative states, very often those state Supreme Courts, I've seen cases out of Tennessee, out of Kentucky, places like that, where those state Supreme Courts are more protective of individual rights than the US Supreme Court. And so a good lawyer will make his or her challenge under both constitutions, the US Fourth Amendment and the state Fourth Amendment, which usually, by the way, this may sound odd, usually tracks the federal Fourth Amendment word for word. And yet the state Supreme Court has interpreted it more expansively. So be on the lookout for that. And that is something that happens very, very frequently these days. Didn't used to happen at all. But in the last 25 years or so, we're seeing a lot of that. All right, let's assume the motion to suppress is denied, or even if it isn't, is denied, or if it isn't, the government has enough evidence other than that to continue, so we go to trial. You're all aware that the burden of proof everywhere in America, state and federal, is guilt beyond a reasonable doubt. And guilt beyond reasonable doubt is a very high standard. And I'll, just to give you a sense, because this is a real issue that many, many people don't understand. And judges struggle to give an instruction on it so that jurors appreciate what that means. And they usually begin by saying, judges do, ladies and gentlemen, this is the kind of care you give to this decision you would give to the most important decisions in your life, right? And I remember when I was a young lawyer in Massachusetts, I remember hearing a judge in a criminal case say, for example, the decision of whether or not to buy your first house would be the kind of decision that you would give the kind of consideration we're talking about here. Now, I was 25 years old, okay? I didn't own a house. I didn't have any children. I went home and I said, buy a house? What's the big deal, right? Compared to whether somebody goes to jail for life. Then I bought a house. And I kind of had a little different view of that, okay? I still don't think that's a great instruction, but you're getting the idea. It's sort of the judge making an effort to try to explain to people how serious, how sure you have to be before you, in fact, find somebody guilty or not guilty, by the way. And so beyond a reasonable doubt is true in the United States. It's true in most countries in the world, by the way. Even countries like the European countries that do not have juries. By the way, as an aside, we are one of very few countries in the world that has juries. We're one of maybe almost, I guess, none that have juries in civil cases, right? Most countries in the world do not have civil juries at all, even England. And only a few countries have juries in criminal cases. And in Italy, where I often teach, you will find that the few cases that have juries have what are called mixed juries. That is 2 judges and 5 and 4 regular people. Well, I think you can figure out who's going to control that jury room, okay? And everybody in Italy says, yeah, we call it a jury, but come on, we know what happens, particularly since in those countries, the jury must write a written opinion, could often run to 150 pages to justify what they're doing. Well, no juror who's not a judge is going to do that, okay? Here, interestingly, and this may be a problem with our system, jurors are sent out in criminal cases, sometimes civil cases with more detail, but in criminal cases, generally speaking, guilty or not guilty. I mean, you've seen this on TV. That's accurate. They don't ask them why or how, or did you consider this or consider that. In the United States, the trust in the jury is extraordinary in our system. Now, I'm not going to say everybody in America still believes that, but in fact, that's what our system believes. And that they give you a reason. They don't have, give you the verdict. They don't have to tell you why. And bear this in mind, in the United States, so in some states, like I believe Wisconsin, by statute, a jury is permitted to nullify the law in rendering an opinion. Example, somebody's charged with simple possession of a small amount of marijuana. The government decides to prosecute. The evidence is clear. The search was good. The person possessed the marijuana. A jury in the United States is free to say not guilty. And there's nothing the government can do. Okay? Nothing the government can do. Double jeopardy attaches and the defendant walks out the door because that group of jurors decided we think it's silly to prosecute simple possession of marijuana. That can and has happened. Okay? The judge does not tell the jury they have that power in most jurisdictions for obvious reasons, because the judge does want, and most of us want the jury to follow the law. But in point of fact, and jurors don't know this most of the time, they have the power to ignore the law. I don't particularly think that's a wonderful thing, not just as a lawyer, but as a citizen. And I'm not going to pretend to you it happens, 3 times a day in Philadelphia. It happens very rarely, but it certainly can happen. At the trial, as you probably know, the order of the trial is pretty straightforward. The government gives an opening statement. Defendant usually gives an opening statement. Defense lawyer could waive the opening statement at the outset of the trial and wait till the government rests to make an opening. Something you can do, not something I usually advise, but something you can do. The opening statement, when you listen to it in a courtroom, is not evidence. This is the lawyers giving a partisan view of the facts and a preview of what their evidence will show. Now, there are some limits. Lawyer in an opening statement from either side cannot offer evidence or to tell the jury you're going to see evidence that's inadmissible, obviously, okay? Or is very contested on admissibility because the judge may eventually, during the course of the trial, sustain an objection and that evidence won't come in, okay? But as long as you're sticking to evidence that you know is going to be offered and admitted, you may talk about that evidence in previewing the evidence of the trial. But what you say there, and the judge will instruct the jury, what you're about to hear from these 2 partisan advocates, okay, is not evidence, okay? Listen to it, enjoy it, think it's silly, whatever you like, but it's not evidence, okay? Then, of course, the government calls witnesses, and the evidence in the United States is taken by live witnesses and by documents, which have been authenticated by the witness, so we know the document is what they say it is, what it purports to be. And the government puts its evidence in a criminal case, and then eventually when it's done, rests, meaning we're done with our prima facie, our initial case. And the defense will then, as a matter of course, move for a directed verdict or a motion, or move for a verdict of not guilty, depending on where you are and what it's called. Or in the federal court, it's now called a motion for judgment at that point, okay? What that means is the defense is saying, Your Honor, the government's put its best case in, okay? If you believe everything they say, if the jury were to believe every single thing the government put in, it's still not enough to yield a guilt by reasonable doubt verdict. Most of the time, that is rejected by the court, okay? Most of the time, not all the time, but if the court accepts that motion, the case is over and the defendant goes home. But let's assume, as what happens in 95% of the cases, that motion is rejected. Defense then has the choice, putting its case on, or, very interesting, in some cases, the defense chooses not to put a case on, okay, which is the defense's choice under the Constitution. And they may make this decision. We feel so strongly that a jury will have a reasonable doubt based on the government's case. We are not going to put any evidence in. We'll go to closing argument and argue reasonable doubt to the jury. Very risky proposition. Obviously, maybe some considerations were, I don't have any good witnesses. If I call them, they won't play well. I don't want to call the defendant. We'll come back to that in just a moment, okay, for a variety of reasons. And I'm going to just, live or die, if you will. The lawyer, of course, always goes home, but live or die on reasonable doubt. More often, though, the defense puts a case on, calling its own witnesses, offering its own documents, whatever. But I just mentioned, do you call the defendant or not? And this is the toughest decision I think most defense lawyers will tell you in any criminal case. And that is, wow, do I put the defendant on or not? Now, you might say, and there are really good arguments both ways, by the way, the majority of lawyers will not put their defendant on in the usual case. They're certainly in a violent crime case for a couple of reasons, okay? One of them is if the defendant testifies, the defendant's prior record can now be used to impeach his or her credibility in front of the jury. If the defendant does not testify, the jury would not know that this person has a very long criminal record. Now you appreciate that's critical. Let's be clear. And I'm a former public defender, but if I'm on a jury and I hear that the defendant in my case, he's on trial for murder and has committed 4 other murders, I got to tell you, I know the law, okay? I'd like to follow the law, but am I supposed to pretend I didn't hear that? I have to tell you, my attitude might be, why is he on the street to commit a 5th, right? That might be my response. And I'm a lawyer and I'm a former defense lawyer, okay? So appreciate how the average person would deal with that. So I would tell you, and everyone agrees, and there have been hundreds of social science studies on this, that when a jury hears a defendant's criminal record and it's something other than a couple of, I don't mean to minimize DUIs because they're horrible, okay? A couple of those, basically the only question now is sentencing, okay? That case is essentially over because the jury makes the inappropriate decision, instructed by the judge they're not supposed to do this, that because he's done it before, she's done it before, he or she has done it again, or they are bad people. So that militates heavily against calling a criminal defendant. Now, the downside, you interview jurors after a criminal trial where a defendant doesn't take the stand. You ask them, what do you think about the defendant not taking the stand? Universally, you're charged with these heinous crimes. If I were charged with one of those crimes, I couldn't get up there fast enough to say I didn't do it if I were innocent, right? I couldn't, I'd be chomping at the bit, running to the stand to say I didn't do it. And when you're on the stand, usually the first question you are asked by the defense lawyer is, Mr. Smith, did you do this? And you get a ringing, absolutely not, right? Well, jurors expect to hear that. Because if they say, if it were I, and remember, key proviso, if I were innocent, right, I would get up there and tell everybody that. So jurors draw bad inference from that, even though they're not supposed to, that the defendant didn't take the stand, okay? The judge instructs a jury, don't consider his prior record on whether he did this crime. Juror ignores that most of the time. Second, if he doesn't testify, don't hold that against him. That's in the Fifth Amendment. And the jurors, sadly, or whatever, maybe realistically, do often seem to hold that against. So it's a very, very tough call for a defense lawyer. Very often there's another important consideration. And this is where there's usually sort of a more or less of a violent situation where the defendant may have a really tough background. And the fear is if I put this defendant on, it was not a lot of education and not a lot of sophistication. The prosecutor who has both will be able to really make the witness, the defendant witness, even if innocent, look really, really bad. And he or she just won't come across well. And that I hear a lot from defense lawyers, particularly in state court, where they're not representing white collar types, but folks who have little education, little sophistication, and again, are not used to the back and forth that you would get, not many of us are, from a good prosecutor. The other item I'll mention is expert witnesses. And again, I want to point out to you, and I think you're probably aware of that, the United States is again one of a minority of countries where expert witnesses are partisan experts. That is, the government puts on an expert and the defendant hires its own expert. And they clash. And the expert for the government says something that implies guilt, and the expert for the defense on exactly the same, factual matrix will say, no, something else, okay? In other countries, in Europe, for example, the judge appoints a neutral expert from a list of experts provided by the professional society, whether it's the German Society of Physics, or the French Society of Microbiology, or the French Medical Society, whatever it might be. But in the US, we have an adversary system, and these adversary experts, of course, clash, and they're often paid enormous amounts of money, not in criminal cases generally, unless, again, a very wealthy defendant. But in fact, the jury, their credibility, again, becomes as important as the lay witnesses who testify in the case. And again, realize the United States is in a rather minority in that, of having what we'll call partisan paid expert witnesses. And as you know, you've heard this and probably believe it yourself, there's a lot of skepticism about testifying experts in the United States because they're being paid for their testimony. And, a lawyer could go through 3 or 4 of them till he or she gets the right expert, and then selects that expert, and no one would ever know about that. And so that's sort of problematic, I think, for all of us. At the end, there are closing arguments. In this situation, lawyers can then talk about evidence that was admitted. They may ask the jury to make reasonable inferences. They may argue the credibility of witnesses, which you could not do in the opening because they haven't even testified yet, right? We don't know if they will testify. And closing is really not quite what it appears. Most lawyers will tell you that the purpose of closing, well, there is one generally accepted purpose, and that is to sum up and collect all of the evidence and put it into, an understandable box, if you will, that the jurors can use and then apply the law to and make a decision. Obviously, in the closing, you're trying to simplify, trying to put things in order, though they may not have come in order at the trial, given the availability of witnesses, and then help the jury reach a verdict. But more sophisticated lawyers will tell you this. What you're really trying to do, assuming a jury, is give fodder to the favorable jurors to you, and you don't know who they are, you may suspect who they are, right? To the favorable jurors on the panel who will then advocate for your position in the jury. And so the closing requires great preparation. You don't want to simply read the closing. You really want to connect with the jury and look at them face to face. You cannot address them individually, obviously, okay? You can't individually. I just saw, by the way, a question came up, are jurors allowed to ask questions? And that's discretionary. Some judges do permit the jurors to ask questions, but it's done usually through the judge. That is, the judge will take a limited number of questions. They will be handed to the judge, and the judge will make sure they're not inappropriate, like asking if this guy didn't testify, but does he have a criminal record? Well, the judge won't ask that question, right? Won't answer that, or have that question answered, okay? And the judge filtering it will do that. Most courts do not. Most courts do not. More and more courts are permitting jurors to take notes. The theory behind not allowing it is that some jurors will take notes, others will not, and then those who take notes will be considered more reliable in the jury room. And people won't trust their own memories because, hey, juror number 6 wrote down what this witness said at the moment, okay? Other judges said, no, I think notes are very important, and encourage it, And that is simply a matter in the discretion of the judge. Now, the judge in the course of the trial, as you know, in the United States, is not an activist judge. In Europe, the judge asks the questions. In the United States, that's rare, okay? The lawyers ask the questions. The judge's job is to rule on objections, which is very important, and to give instructions to the jury as to what the law is. Okay, those are the two main functions that the trial judge has in the United States. And errors in either rulings on the evidence or a faulty instruction to the jury, one that misstates the law. And by the way, in fairness to many trial judges, this may be a case where the appellate court changes the law out from under the judge. So it's not the judge's fault, right? That every time Supreme Court announces a new precedent, that's happened or could have happened, right? But the judge has that limited role. Now, the other day I saw Steve Bannon convicted in Washington, and his lawyer immediately comes out, and here's what he said. It always makes me laugh. I might be wrong in this case. What did he say? He didn't say we have a slam dunk winner on appeal, but it was words to that effect. Okay. Let me tell you a little secret about appeals. Okay. Your chance of winning a criminal case or a civil case on appeal, your chances are extremely remote. Okay. I remember I used to get something called the Federal Rules of Evidence Service, which reported every written opinion on evidence from a federal judge anywhere in the United States. Came out every 6 weeks. And I used to look at them and you see the Court of Appeals decision where the appeal went. How many judges were reversed on making errors on evidence? 1 out of 20. And why is that? Do judges make errors? Of course. They don't make a lot of errors. Look, they know the law most of the time, okay? But appellate courts are very wary of upsetting jury verdicts. They have enormous respect for the finality of what the jury says. So even if an appellate court says, and I've seen this hundreds of times, okay? Well, the judge made a mistake. The judge shouldn't let this evidence in, okay? And by the way, evidence decisions are reviewed by the appellate courts, not on right or wrong, but on an abuse of discretion. So the judge may be wrong, but not so wrong, the trial judge, that he or she abused his or her discretion, okay? So first, the court can say the judge didn't abuse discretion. It was close enough, okay? Second, even if the judge was wrong, the judge gave a limiting instruction. Judge let evidence in, but told the jury, be careful with this evidence. That's a little simplistic what I'm saying, but you get the idea, okay? Or I let this evidence in, don't consider it for this, but do consider it for that. You know, in the case I gave before, yes, he's committed 6 other murders. Don't consider that on whether he's a good or a bad person, but only on does he know what a gun looks like. If there was a gun used in each case, whatever it might be, okay? Or, and this is the best one for appellate courts to sort of, in fairness, you know, I have great respect for them, to wriggle out of a situation where they know there was a mistake is say, yes, there was a mistake. The trial judge was wrong, but the error was, quote, harmless. Or, as in a phrase only lawyers could love, not harmless beyond a reasonable doubt, which we call the harmless error rule. And courts, what that means is this, the court would say, yes, the judge should not have let this piece of evidence in, okay? The judge was wrong. But if you look at the totality of the case, the evidence was overwhelming. And the jury in all likelihood would have found guilt irrespective of this evidence. If you took this evidence out of the case, it's our belief that very clearly the jury would have rendered the same verdict and found the defendant guilty, all right? So those are 3 ways that an appellate court will avoid overturning a conviction, okay? And so I always, you know, sort of laugh when I hear lawyers and they come out on television outside the courtroom and there are thousands of microphones. Oh, we're filing an appeal. And most lawyers say, yeah, you have fun with that. And, you know, the meter will still be running. You know, you can charge for your time, but we all know that usually, not every time, courts do reverse convictions. That happens. I'm not going to suggest it doesn't. But you know, if you're planning on winning a case on appeal, usually you're not in a good position, not in a good situation.
So,
I'm sorry,
David, I'm going to interrupt you because we're at time, but I want, there are a lot of questions in the
Okay.
in the chat. So I want to ask you some of the questions because
Sure.
you've You are fascinating and terrific. So thank you. So, why would
Debbie,
someone,
tell my family, will you?
so why would someone want to make a false confession?
Well,
Why
I
does that
wish we had
occur?
more time. I've done 2 hours on this. And the answers are many. Bear in mind a couple of things. Many defendants are mentally ill. Many have suffered from mental deficiencies, IQs under 70. In the neighborhood of 35 to 50%
Wow.
of jail inmates, criminal inmates, fall into one of those 2 categories or both. Third, there are coercive methods by the police. And in the United States, uniquely, police are allowed to lie to a suspect in an interrogation and tell them we've got your DNA when we don't. We've got 32 live witnesses, all of whom are Sisters of Mercy. You have no chance. And then the defendant says, okay, what do I have to do to get out of here? A lot of reasons, but that happens. And most of us find that hard to believe, but they do.
So is it, in your opinion, right? This is opinion. Is it a good thing that a low number of cases go to trial?
I do not. In Italy, for example, every case must go to trial. There's no guilty pleas. Okay. Every case. The theory is the state should have to prove its case, and the defendant should put on whatever he or she has. Okay. So not a guilty plea, except in extraordinary situation in Italy, is forbidden. It's forbidden. Okay. I'll add as well, by the way, in Italy, you're not allowed to waive your right to counsel in an interrogation. One added point on the earlier question, Debbie, I'm sorry. 70 to 80% of people waive their Miranda rights. So despite being told they have a right to counsel in the interrogation, the vast majority of people waive that right and are interrogated without counsel. If counsel were there would be essentially no false confessions. No lawyer would allow that.
Right.
No lawyer would allow that.
To what extent have you observed that ineffective assistance of counsel is a result of, the public defender's office being, underfunded and understaffed?
Yeah, and now again, I gave you full disclosure. I used to be a public defender
Right.
for a brief time in Boston. I will tell you this from the Innocence Project point of view, okay? We have never seen a case of ineffective assistance in a case we've taken where we exonerated, where the lawyer was a public defender. Now, I didn't say almost never, I said never, okay? Never. Public defenders get a bad rap on television. I would like a lawyer, a paying lawyer, hear suspects say, et cetera, in TV shows. Public defenders do a wonderful, wonderful job. Most of the time, apart from, if I'm a multi-billionaire, probably rather have a public defender.
Okay. So there is a question here, which is an interesting question, as to whether documents from motions to suppress hearings are available post-hearing.
Yeah, I would think the answer would be yes. I've never faced that issue with thought about, because nobody's ever asked, right? Whoever wants to see motion to suppress stuff? But the answer is yes. And very often the appeal in the case is an appeal of the denial of the motion to suppress, in which case all of that will be available in the transcript and in the appeal documents in the Court of Appeals of the Supreme Court of the state. So that stuff is accessible.
Okay, great. All right, and the last question: have you done other lectures that are available by Zoom?
in the last 2 years, yeah, Zoom is my life.
Okay, so I may reach out to you and get some of the links, and we can share them with the participants.
That's right. It's usually on civil stuff, though, so I don't know if it'll be used in this group. But the answer is yes. And I got to tell, I don't think you lose too much.
Right. Okay, well, I want to thank you so very much. I want to give everybody here a break. We're going to start at 10:05, and we'll start with information about civil litigation. So thank you all, and see you in 5 minutes.
Thank you, Debbie. Thank you, audience.
Okay, I'm gonna start. Can you all hear me? Somebody just give me a thumbs up. Hopefully. Okay. So I'm speaking on covering civil litigation 101. While I'm the CEO of Pennsylvanians for Modern Courts, I spent over 30 years practicing complex commercial civil litigation in state and federal courts across the country. I know that many of you are from the outside of Pennsylvania, so I will touch upon that, but you'll see many of the implications are for covering civil litigation are the same no matter where you're located. So how do you cover a case, a civil case, or even a criminal case? You need to do some research about the case. You need to find out what court it is in, what courthouse, what judge, what rules are involved, what has occurred in the case to date, what civil law violation is alleged, who you can reach out to for your answers, and what are you covering. So each of these topics we're going to address. And again, please put your questions in the chat and hopefully I will get to them. So what court? So are we in a state court or a federal court? A little bit about Pennsylvania's state courts. They are a triangle. Our highest court is our Pennsylvania Supreme Court. It has the least, I'll say, or fewest number of cases, right, that before it. And typically it has cases that it has discretion as to which kinds of cases it can take. Takes cases that it feels are important in setting precedent. It also always takes the death penalty cases. Every state has its highest state Supreme Court. 97% of cases in this country are filed in state courts. Below the Pennsylvania Supreme Court in Pennsylvania are two intermediate appellate courts. Pennsylvania is unique in that it has a Commonwealth court. No other state in the country has that. Our Commonwealth court handles issues that have been brought by municipalities, state and local governments, or against municipalities, state and local governments. Our Superior Court handles all kinds of appeals from the lower courts. And they do not have a discretion as to which cases they can take. So our Superior Court is very busy. The most common, I'll say, or frequent court that most people are familiar with are our Court of Common Pleas. It's an entry-level court. It handles civil and state. It handles family it handles family law as well, landlord-tenant. But most matters here have to be above $12,000. Pennsylvania has what are known as courts of limited jurisdiction. In Pennsylvania, they're known as the magisterial district courts outside of Philadelphia and Pittsburgh. In Philadelphia and Pittsburgh, they're called the municipal courts. They are typically small claims courts. Most litigation in there is pro se. This is now the federal court system. That's what most people are familiar with, but again, has the fewest number of cases. And as Judge Kearney said, his docket, the cases before him, only 10% of matters before him are criminal. Again, another triangle, the highest court, the U.S. Supreme Court, we only have one in our country. The United States Courts of Appeals, there are 12 different regions, I'll say. That includes the District of Columbia. So there are 11 regions plus the District of Columbia. And then there's technically a 13th Court of Appeal, and that is the Federal Circuit. That deals with matters such as patent litigation. We have district courts, 94 different district courts across our country. And the district court is the entry level court for federal matters. Federal matters, what is that? It's a federal statute or involves a case that is greater than $75,000, and there is a plaintiff and a defendant from a different state. I've also included in the federal system is the U.S. Bankruptcy Court. So this is the map of the United States divided into the 11 regions, the District of Columbia, and the Federal Circuit Court. Hold on, I just want to admit some people. Okay, sorry about that. Okay, and again, the Federal Circuit Court, what does the Federal Circuit Court of Appeals, because it's a unique court, it takes matters from Federal Claims Court, Court of International Trade, Court, it's the Court of Appeals for Veterans Claims, it takes patent litigation. It is a very unique court in our country. So we've now figured out what court, right? Okay, is the matter a federal case, or is the matter a state case? But what courthouse and who is the judge? These are very important things for you to figure out. You need to figure out if you're going there, if you're going to participate by Zoom. There is so much information available on courts' websites. The federal court that Judge Kearney sits in is available, here's an example, www.pad.uscourts.gov, but every district court has its own website, federal district court has its own website, every federal circuit court has its own website, and so every state court and municipality has its own websites. This is a sample of the website for the Eastern District of Pennsylvania and the types of information you can find there, right? You can find anything, you can find out about the court location. The Eastern District of Pennsylvania is not only located in Philadelphia, but there's also courthouses outside of Philadelphia. You can find out information about the judges. Every judge has his own rules and policies and procedures. You need to find those out. There is information about we'll get to it a little later, but the court's own rules. This is truly a wealth of information, I will say. So, okay. This is the Court of Common Pleas. I wanted to give you an example because, we think, okay, a Court of Common Pleas, it sounds like there's only one court. Well, in Philadelphia, we have a trial division that has civil and criminal, and they are in different locations, different courthouses. Excuse me. There's a family division, which handles family matters, domestic relations, juvenile court. Excuse me. It's in another location. And finally, there's an orphans division, which I always say, why is it named Orphans Court? Because it handles estate matters, it handles guardianship, and the orphans division is in Philadelphia in City Hall. Excuse me. So we've now figured out where the court is. Okay, which court, where the court is, but we need to know what rules govern the courts. Okay, as Judge Kearney said, he can't just go out about making law. Okay, so there's many different rules that govern the courts. We have federal laws, federal rules, we have state rules, we have local rules, we have rules of judicial administration, and we have judges' rules. So how do you find out about all this information? Well, there's a lot of federal rules. Federal rules of criminal procedure, federal rules of civil procedure, federal rules of evidence, federal rules of appellate procedure. They govern each court. Federal rules of appellate procedure govern the Court of Appeals. Federal rules of criminal procedure and federal rules of evidence govern criminal law cases. Federal rules of civil procedure, federal rules of evidence govern civil cases. All this information is now publicly available on the web. I don't expect you to be an expert, but sometimes you can go to them and it may answer your questions. Then there's state rules, okay? Every state has their own set of rules. So in Pennsylvania, there's the Pennsylvania Rules of Criminal Procedure, the Pennsylvania Rules of Civil Procedure, Evidence, Appellate Procedure. Every court has its own rules. So juvenile court procedures, domestic relations rules of civil procedures, orphans court procedures, minor court civil rules, and then there's the rules of judicial administration. So while the lawyers need to know about all these rules when they're in court, the judges need to know about all these rules, but sometimes it will help you in understanding how you're covering a matter. And then, again, So we now have the federal rules for governing federal matters. We have the state rules. California has its own state rules governing, its state matters. But then underneath that, each specific court has its own rules. So the Supreme Court has rules of operation and guidance. Every circuit court has its own rules of procedure and operating rules. And the district court has its own local rules. There are so many rules, you don't even know what to do. So how do you find out about this information or what rules govern a matter that you're covering? Again, you could check the website. You can always call the clerk's office. Every court has a clerk. Most times they speak to you. Some courts have actual media offices that you can reach out to. You could also call the judges' chambers. The judges will not answer your questions, but the clerks in their chambers may. Or you could also call an attorney. Last year we had Cherry Gregg on our program, who is an attorney and a journalist and is on WHYY now. And she always talked about how when she has a question, the most important thing she did was reach out to attorneys that she knew to help them navigate the waters. So, but you shouldn't enter a courtroom, okay, if you're covering a trial without some basic knowledge. And the reason is, you need to find out, can you bring your phone, computer, or recording device? If you try to record or take a picture, are you going to be violating some law? Can you transmit information? Can you send an email while you're covering? Is there any kind of confidentiality or non-disclosure in the case that you're covering that you need to be aware of? So to me, these are the most important things that you need to know when you enter a courtroom, because you don't want to get yourself into trouble, right? So for example, as we discussed with Judge Kearney, in federal court right now, in the entire United States, there is no permission to record or take pictures. And then not only is it in federal court, but for example, Rule 83.3 is the local rule of civil procedure for the Eastern District of Pennsylvania. There are proposals in Congress right now to allow cameras and to open the courtrooms. Zoom honestly has been a benefit in that many of the judges now do hold hearings that are Zoom accessible, but you cannot record them. You cannot take pictures of them. So just know that. Similarly, in Pennsylvania, we do not allow cameras, phones, recordings of our cases. You'll hear later from an attorney and a judge from Arizona who will tell you about a different experience, and they do allow cameras and recordings in their courtroom, but Pennsylvania does not, and you can run into yourself a violation of a law if you bring your cameras and try to record matters. So that's the first type of rule that you need to actually look into. But the other type of rule you need to look into is what types of information are confidential and shouldn't and are not allowed to be disclosed. So parties, when they file documents or have certain requirements as to how they file them, they have to black out or cross out confidential information. In Pennsylvania, and again, every state is different. What documents are confidential? Financial source documents, minors' educational records, medical, psychological records, children and youth services records. What other type of information? Social security numbers, financial account numbers, driver's license numbers. All this information has to be and should be blacked out. And so therefore, you should not be transmitting that kind of information either, because there are rules against its disclosure. Also, in certain matters, the parties themselves have entered into confidentiality agreements. So that means that they themselves, maybe it's a big, trademark matter, or, one business suing another business, and there are certain documents that have confidential information. If it is an open trial or an open hearing, the parties typically will bring to the attention of the judge the fact that these documents, this information is confidential. And, is there a concern with not allowing that information to be shared with the public? So every case is different, but you need to find out what governs the case that you're following. Now, how do you find out information about a specific case? All court filings are available electronically, almost. Some states do not yet have electronic filing, but, in that case, you can go to the clerk's office, the old-fashioned way, ask for a copy of the docket to see what has occurred in the case, to see what information you want to read. And, the court, if you're going to the clerk's office, they are required to let you look at the docket. Electronically, some are free, some are not. Some court websites will link to important information. And then you could also reach out to the media contact for the courts to see if you could get a copy of the documents. So here are a few, we're going to talk about the information that's available at the different courts. So in federal court, they have what's known as PACER, Public Access to Court Electronic Records. It is available across the United States. Every federal district court document is available through PACER. You need to sign in and have your own account. Opinions are free, or should be free. Documents and pleadings are not necessarily free, but there is a limit on the amount of money that the government can charge you for getting copies of documents. Opinions are available on a different website, on many different websites. You can get them through PACER, but you can also now get them through this govinfo.gov website. It accumulates opinions across the United States. It asks you, as you see, what court, if you have some kind of information about the case that you're following, the name, the civil action number, you need to put that in. And you will be able to access that information. And oftentimes opinions contain a lot of information about the case, including like referring to documents that have been filed in that matter. There's also in federal court cases that fall under the heading MDL. They're multi-district litigation cases. So they're cases that have been filed all in many different courts across the country in federal court, and they have been consolidated in front of one judge in one location for pretrial purposes. As an aside, there's a court called the Judicial Panel on Multi-District Litigation that meets all over the country, and so that panel decides which judge will be assigned to handle this multi-district litigation case. The multi-district litigation cases are typically listed on the various federal district court websites separately, and they also list documents filed in each MDL case separately. So for example, here in Eastern District of Pennsylvania, they have listed, almost a dozen MDL matters. You click on the asbestos products liability litigation, for example, and you would be able to get various pleadings filed in that MDL litigation. Okay. In Pennsylvania, we are known as a unified judicial system, but it's a little misleading. So you can access in Pennsylvania docket sheets for the Pennsylvania appellate courts, the criminal courts of common pleas, the magisterial district courts by using this UJS portal. You cannot access civil matters using the UJS portal. And we'll discuss that because every civil matter in every county in Pennsylvania has different rules as to whether their dockets are electronically filed. They operate they operate through each county's prothy or prothonotary. Pennsylvania has an PA docket system through an app, and then what opinions are publicly available, and you can do that through the pacourts.us website. And again, every state is different. But Pennsylvania, for criminal matters, you can access the docket through the UJS portal, get copies. You can get a copy of that motion for suppression. You can get a copy of the court's decision on that. In Pennsylvania, for appellate courts, this is just simply an example of what it looks like when you go into the UJS portal looking for a decision or filings, pleadings. In an appellate matter, you have to search need some kind of information, whether it's the number of the case or where it came from or a party name, but you do need some kind of information in order to access it. Okay. And this is the first judicial district is the name for the Philadelphia County court system. Okay, so it's courts.phila.gov. You can find out information on the calendar and case information. You can search for a specific court case. You can see here, you can search for, the debt collection cases, civil dockets, civil criminal filings, traffic dockets. And this is what it looks like if you are searching in the civil docket access in the first judicial district, which is in Philadelphia, right? You can search by a person's name. You can search for a judgment. It's really important that you be able to have a little bit of background on the case that you're covering. And so this is the way that you can do it. Allegheny County, as I mentioned, has a different filing and retrieval system, and you go into it, through the AlleghenyCourts.us. And, again, every county in Pennsylvania has a different electronic filing system for civil matters. So Montgomery County, this explains how you go into their website. So it is not, I'll say, the easiest. Federal court system is much easier. The PACER electronic system applies for every district court in the country. You have to dig a little deeper when you're covering a matter in Pennsylvania's state courts in different counties. And again, for Montgomery County, it's a search through the Montgomery County prothonotary, and this is what it would look like in order to access dockets. So, what types of information, right, can you find when you go online? And this information is really important for your covering the matter. You can find out the names of the parties and their attorneys. And as I think it was David who said, reach out to the attorneys. They may or may not talk to you, but they are clearly the best source of information. Keep in mind, they may or may not talk to you because there may be an order from a judge saying they can't talk to the press, but it's worth a shot. You can also find out the name of the judge. Again, the judge may not and most likely will not talk to you about a matter that is currently pending before the judge or would be before the judge in the future, but it'll help you find out information about the judge's own practices and procedures. And you can even look up, different decisions by judges. So you can understand if there's a pattern here about how a judge handles, a particular kind of case or a particular matter. The docket information should tell you the status of the case, when hearings and trials are scheduled, And hearings and trials are open to the public so that you can just go in. You don't have to announce yourself. You don't have to ask permission. But again, you should check and make sure that as to the requirements or limitations of your recording and taking pictures. The dockets will also contain pleadings. Pleadings is a fancy legal name for just documents, right? And what types of pleadings will have been filed in a civil case? David discussed some of the pleadings that would be filed in a criminal case, such as motions to suppress. But in a civil case, the pleadings that are filed, or the first pleading, is a complaint. The first document in the matter usually tells one side story, and it should state which laws are violated and list the remedy requested. You can do your own homework if you want into what burden of, what a plaintiff needs to prove in order to show that the law's been violated and what types of remedies, are available. But the complaint should have a lot of that information. After a complaint is filed, typically the next document is either going to be an answer by the defendant, by the party being sued, or a motion to dismiss. Again, it tells the other side's story. In Pennsylvania, instead of a motion to dismiss, we have preliminary objections, and the pleading could also contain new matter or a counterclaim. But there is a lot of information that would be available to you to read in these, in these pleadings. Discovery, interrogatories, depositions are not typically filed with the court. These are matters typically between the plaintiff and the defendant. However, you can get that kind of information when there's a motion, there's motion, what's called motion practice, and therefore the parties are disagreeing, for example, on what each side has produced. So there would be a motion to compel. So in the motion to compel filing, the parties will submit the discovery that is being challenged. So you'll get that insight. And then when there's a decision on the motion to compel, you'll also be able to get an insight into some of the information. Sometimes it is confidential again, and those documents that are filed with the court are filed under seal, but there still has to be a document that's filed with the court that literally just blacks out the confidential information. There are various motions that can be filed in civil court in civil matters. There's a preliminary injunction motion, a summary judgment motion, judgment on the pleadings, motions in limine. These are all fancy legal terms, but there's a lot that, to me, what's most important for you is that this contains information that you can use in your reporting. David Sonnenfeld talked about expert testimony. Well, in the parties will, before a trial, may submit motions in limine trying to eliminate the opponent's experts that's been proposed. So in that motion in limine, you'll have information about that expert, maybe that expert's CV, what other types of matters that expert has testified on. This is a lot of information that you can use for your covering the matter. Finally, the docket will disclose whether the matter has been dismissed, how it's been dismissed, right? Is it a voluntary dismissal? Is it a dismissal because the parties, with prejudice or without prejudice? Is it a dismissal because the parties have reached an agreement? Is there a settlement of this matter? And sometimes the settlement documents will be filed with the court, or whether this matter went to, trial and there is a verdict. So there is a lot of information that can be found online and that, you really should look into before going into a hearing or trial cold. So there are trials, right, in civil litigation. And there's two different types of trials. There is a bench trial and a jury trial. Now, bench trials rarely happen, so you know it, right? They're not that frequent, but sometimes the parties will agree that they want to have their matter heard before a judge. You know, why could that be? It could be because it will get resolved in a more expedited basis. It could be because the counsel for the matter have confidence in the judge as opposed to having the uncertainty of a jury. Equitable claims are heard by, in a bench trial by a judge. However, if you have a matter that has an equitable claim and a non-equitable claim, that can and should, in all likelihood, go in front of a jury trial. We've all heard about jury trials, but in most state courts and federal courts, you need to actually make the plaintiff who's filed the case and the complaint needs to actually make a jury trial demand. It could just be simply a 3-word statement on the complaint that says jury trial demanded, but it needs to be clear to be made clear that a jury trial is demanded in many states. So there is a difference in the burden of proof in a civil matter versus a criminal matter, right? In civil, it's a preponderance of the evidence, and in criminal, it's beyond a reasonable doubt. So therefore, preponderance of the evidence really means just the scales just have to be tilted ever so slightly, 51% really. And the court will address, and the parties will address evidence as to whether it would be admissible and is it relevant, right? It has to be, material and relevant in order to be admissible unless it is not competent. So there are many different rulings in a trial, even in hearings, as to the materiality, the relevance, the competency, the probative value versus the prejudicial value of evidence. The courts spend, I would like to say, most of their time in dealing with evidentiary issues. We hear about hearsay and exceptions to hearsay. So before a trial begins, many evidentiary issues are brought to the court. What type of questions or discussions could be presented to ahead of time before and outside of the jury's, hearing. Jury trials, the size of the jury varies by state, by court. Typically is from 6 to 12 members. In Philadelphia, it is a 6-member jury. Outside of Philadelphia, it could be anywhere from 6 to 12 members. It really depends on the court's policies and procedures, so you need to look that up. Voir dire. What is voir dire? It's the questioning of potential jurors to see if they will be selected for the jury. And again, what type of voir dire is permitted varies across the state and across the federal courts. Some judges will do the voir dire themselves. Others let attorneys do it. Others have a list. Other judges actually have a list of questions or ask the attorneys for their voir dire questions ahead of time and then decide which ones can be asked. There are various ways that jurors can I'll say not be selected or can be challenged, right? There's challenges for cause and peremptory challenges. And again, these challenges differ as to what's permitted based on different state laws and versus the federal law. The jury trials themselves can last, anywhere from a day to months. Complex civil matters trials can last 3 to 6 months. I used to practice securities, antitrust, and consumer class action matters. Those cases, as David said, rarely go to trial. I would say in my 35 years of practice, there were about 15 of these class actions that went to trial, and the cases lasted for months. Judges wanted to keep the trials condensed and short, and as concise as possible, but sometimes it's just not, it's not possible. So the jury, this is the process of the jury trial. David, went through this with you, but there's, again, an opening statement. That's the story of the party that brought the lawsuit, and all it is a story. It is not presenting evidence, but it is telling the story so that the jury knows what to look for. Then the plaintiff puts on their case. Sometimes in a civil matter, while it's nice to have it all organized, witnesses may not be available, at certain times, and so the case may go, I'll say, out of order, but that only proceeds with the judge's permission. So the plaintiff puts on their case in chief, they bring on their witnesses, the witnesses are cross-examined by the opposing party. Then there are, expert witnesses presented, there are exhibits presented, there is rebuttal testimony, there's a lot of objections to exhibits. Usually in civil trials, the parties try to work out ahead of time jointly documents that will have no objection, that both sides will use, that are admissible. Sometimes they even provide a loose leaf for jurors to actually have the physical documents that are referred to in trial or on the screen, but the parties will usually agree to which documents are included in a binder. The plaintiffs, with the burden rests, is there then a directed verdict by the defendant? Has the plaintiff put forth enough evidence to make its case? The defendant then, if the court will sometimes take that under advisement, may rule on it immediately, but highly unlikely, then the defendant also would present its case similarly through witnesses, through documents, through deposition testimony, and then there are closing arguments, instructions to the jury, and then there's a verdict form. First, the instructions to the jury, they go out, they can't come back and ask questions. I think somebody asked, can jurors ask questions? Typically, it's up to each judge's practice, but once they go into the jury room, they can come back with questions. They give it to the judge, who then will decide, if that question can be answered and in what way. They may ask for a specific piece of evidence to review. And then the jury can reach a verdict. In federal court, civil matter, it needs to be unanimous verdict. In Pennsylvania, it needs to be 5-6. In California, it's 3/4 of the jury. So again, every state has different requirements, and it's important to find out what they are. And after a jury verdict, usually that means one side is not happy. So there are post-trial motions to ask the judge to maybe review the evidence that's been presented, or in order to lay the groundwork for appeal. So, appeals, we've discussed it. Every state has their own appellate court, federal courts. The federal system has the Circuit Court of Appeals, and there are rigid requirements with respect to time for appeal. There is no flexibility here. If a party misses its time for appeal, then the case will be thrown out. Again, for appeals, the parties must be appealing a final order. Otherwise, the appellate court will not take that matter. Interlocutory orders are only allowed to be appealed if there is a rule or a law saying they can be. So, for example, in federal court cases, in class action matters, you used to only be able to appeal final orders. So therefore, as a complex class action was being litigated, the course of procedure, I'll say, is that the class would be certified before you got to, it had to be certified before you got to trial or summary judgment. It didn't have to be certified before you got to summary judgment, but that class certification could not be appealed. The rules have changed, and now that class certification order can be appealed. And what is put in the record is the lower court opinion, as well as the record from below. And the standard of review for appeal for most cases is an abuse of discretion. Is there an error of law? Is it a harmless error? These are topics that Professor Swann, that David had discussed. But it's really important to understand what standard. Some standards of review, if depending on the matter that's appealed, are de novo, right? Meaning that the appellate court is looking at this from the first instance. But other issues which are appealed are whether the lower court, whether the judge abused his or her discretion in making that decision. Appeals have a lot of information. You have the entire record from below. You have the briefs that are filed with the appellate court. You have oral arguments. I recall seeing a question in the chat as to how it is determined whether there is, one judge hearing a matter or 3 judges hearing a matter. And an appellate argument in Federal Circuit Court of Appeals is a 3-judge panel. If you have filed that appeal, the court has, that appellate court has issued its decision, there may be, I'm only going to say, an opportunity for en banc review, which would mean the entire Third Circuit would be hearing an appeal of an appeal. The size of the panel or the size of the court varies based on the court and the state. So if you have a matter that's before the Pennsylvania Supreme Court, the entire court will be present for your hearing. But again, it varies based on what court you're in front of and what the state or federal rules are that apply to the matter. Okay, and I think that's all I have. I'm going to stop sharing now, and I'm going to see if there are questions. So, what is an equitable claim and a non-equitable claim? Well, a contract matter is a non-equitable claim. An equitable claim has to do with something that actually came from maybe England, as a matter that I'm trying to give you a specific equitable claim, and I'm drawing a blank right now. But it is provided it is not a statutory remedy. Can you explain why and how some cases get appealed directly to the Supreme Court? Well, they get appealed to the Supreme. I'm thinking you're saying the U.S. Supreme Court, and they get appealed to the U.S. Supreme Court after a decision from the court of the court below, so the Court of Appeals. In Pennsylvania, we actually do have a procedure where a matter could go directly to our Pennsylvania Supreme Court. It's called a King's Bench procedure, and that it's a matter that maybe is a matter that has precedential value And therefore, the party feels that it's important, and maybe there's some disagreement among the lower courts, so the party will file a motion for a King's Bench appeal directly to the Supreme Court to issue a decision on something that is precedential in Pennsylvania. You also have a situation where a matter could be brought in front of a federal court, but it deals with state court law, and that state's highest court has not yet issued a decision on that issue. So the federal court could actually refer a specific question to that state's highest Supreme Court to ask for how that court would rule on this issue of law. So that's another way it would go directly to a state's highest Supreme Court. I'm trying to see what else. Somebody says, note that PACER bills quarterly. So if your quarterly bill is $30 or lower per quarter, you don't have to pay. I think also if you are interested in court information, actually there are other systems which I forgot to mention besides PACER, but they're available through the internet. So you can, sometimes Bloomberg has court filings, sometimes Reuters has court filings. There is also a public source of docket information that his name is escaping me, so I'll make sure I put it later in the chat. That you can actually, that if the documents have already been pulled up by somebody else, they're available on this public source. So you don't necessarily have to pay for PACER. I would say first search the internet, because the internet has a tremendous volume of pleadings and information, but you know, PACER is always available to you. And I'm almost out of time. Right, free opinions are at courtlistener.com. And I wanted to thank everybody for joining me. We will be sending out information after this program is over. So, you know, again, if there's more questions, feel free to ask them in the chat and we will try to follow up with you. The next panel is going to be addressing, I'm just making sure my panelists are there. I see Paula and Melissa. Okay, sorry. The next panel will be addressing the right to know and information that you can get from various, you know, FOIA requests, open records requests. I want to welcome Paula and Melissa for joining this program. We have had you both speak before, and I thank you for your continued assistance to PMC with these programs.
Thank you.
Thank you. Thanks. It's our pleasure.
Melissa, do you want to go over what we'll be talking about today as you get up the PowerPoint?
Sure. So today we are going to talk about a little bit about court access issues, the presumption of access, both constitutional and common law, some of the rules that impact what you can get from the court system. We're also going to talk about Pennsylvania's right to know law and its cohort on the federal side, the Freedom of Information Act. There's a lot of information to cover. We have, I think our PowerPoint presentation has, like I said, a lot of information to cover. If we don't get to a particular in-depth portion of it, I think the slides speak for themselves. But I also want to say one of my primary jobs is to answer questions from journalists. So if you have a question outside the context of this presentation, don't be afraid to reach out. And Paula's organization is the same way. We both have legal hotlines where we have myself or other attorneys at the Reporters Committee are happy to answer your questions and help you navigate the various processes and rules and policies that impact what information you can get and how to get it. Just as a matter of background, I'm in-house counsel with the Pennsylvania NewsMedia Association. Like I said before, one of my primary responsibilities is answering their legal hotline and providing advice and guidance and assistance to journalists with legal questions impacting how they do their job. And Paula? You want to talk about Reporters Committee briefly?
Sure. I'm the Pennsylvania-based attorney with the Reporters Committee for Freedom of the Press, which is based out of DC. There are 5 lawyers like me throughout the country, Pennsylvania, Oklahoma, Oregon, Tennessee, and Colorado in no particular order. And then we have lawyers in our DC office. We have a 24/7 hotline, and we have a ton of great resources on the website. We'll be talking about some of those later. I want to give a special thanks to 2 of our lawyers from the DC office, Sasha and Gunitha, who are on the training, and they may be dropping in some resources into the chat. So having said our introductions, we will go ahead and get into it. And I think, Melissa, both of our contact information is at the end of the presentation.
Correct. I'm just going to pull up the slideshow right now, if that's okay with you, Paula.
Yep.
And I'll have to hit share screen. From the beginning. Okay. So there we are.
Okay. So Melissa talked about some of the topics we'll cover today. And we know that the panel after us will also be talking about access to information. But one of the questions we get fairly frequently is, are court records subject to the right to know law? And I know there are journalists on this call who are from other states, and I want to make sure that we're all on the same page here, that court records are open to the public. So you don't have to file any kind of request. You can walk into the courthouse and ask to see a document. And Debbie talked earlier in her presentation about the difference between paper records and electronic records. Some courts are in transition. Basically they have some paper records, some electronic records, but the right to see court proceedings, court records, it doesn't really matter whether it's remote, if it was a remote court proceeding, electronic or paper, all these things are open to the public. Here in Pennsylvania, both our state constitution and the federal constitution cover the public and press presumptive right of access to civil and criminal proceedings. But in your state, wherever you are, you probably have similar protections under your state constitution. And we have in the next slide, but not yet, Melissa, I think link out to our resource on the website, but I'll have Sasha drop that in there. She works with me a lot on open courts. You can go to this resource we have on the Reporters Committee website and basically pick your state or pick your federal district, and then, pick the topic. There are a lot of common issues. Can I get into a hearing with minors? Can I get into a hearing that deals with divorce? Thank you, Sasha. So you can scroll through that, find your state, and kind of click on the area you're interested in. Just a note about why we care about open records in terms of the open judicial records in terms of the court system, because it fosters public confidence in the fairness of the justice system. It aids in oversight, and it serves as a community therapeutic value. That's a quote from a Pennsylvania case. But basically, the public, sometimes through you as the press, wants to make sure they understand what is happening in court, and that court processes are treating everyone fairly. So we'll hop over to the next slide. Okay, there we go. So sometimes we hear that court records are sealed. It is possible to seal a record, but sealed court records should be the rarity. We shouldn't see this as a common situation. And on occasion, I think, Melissa, you probably hear this on the hotline too. Reporters will say, well, the parties have told us they've agreed to seal it and the judge signed the order. Melissa, is that good enough?
No, that's not good enough. And that's not consistent with the constitutional requirements for open courts. As you can see here on the slide, there are requirements that a court has to go through when sealing a record or a proceeding. And that includes there has to be an on-the-record finding that closure is essential to preserve a higher value, and that closure is narrowly tailored to serve that interest. So, and part and parcel of that is that the trial court has to give notice to the public and others an opportunity to object and be heard. Sometimes that means you as the reporter stand up in the courtroom and say, you know, I'm here as a member of the press. I object to this sealing, or I object to this closure of this hearing. And you have to explain why. And sometimes that works and sometimes it doesn't. And sometimes you have to stand up and say, you know, I'm here as a member of the press. I object. I would like an opportunity to get counsel involved. And that's when Paula or, you know, your corporate counsel could get involved and say, they could file a motion to intervene and say, these are all the reasons why we think there isn't good cause, or these are all the reasons why this particular remedy isn't narrowly tailored. Do you want to weigh in on that a little, Paula?
Yeah, I just was looking, hopefully folks can see the slides. I see a couple comments. It looks like there's some troubleshooting going on, but Leonie, I don't know if that's how you pronounce your name, has a question about adult guardianship records are permanently sealed. Families can't get their loved ones' records and journalists are not allowed to publish names. Are these requirements being liberalized now? I mean, there are some categories of records that have, let's say, sensitive information like health information or mental health information. And yes, that kind of information can be sealed. Here in Pennsylvania, if you see on the screen, we have what is called the UJS public access policy, and it governs that certain things like minors' names, bank accounts, social security numbers, that they should not be put in court records. And it's the attorney's responsibility to make sure that is not put in. But I would say generally, just because something is dealing with a person in a vulnerable condition, such as an adult under guardianship proceedings, it doesn't mean that there's an automatic seal, and that it really is going to depend on the state and the circumstances. So I don't know what state you're in. I would check out the Open Records Guide there, but traditionally things like children in, dependency circumstances is what we would call it in Pennsylvania. Sometimes those hearings are not open to the public. And I can't say that I'm aware of a large movement to grant more access, although I will say the Free Britney movement seemed to shed more light on adult guardianship or competency proceedings and why more scrutiny is needed there. Melissa, I don't know if you wanted to add anything.
Yeah, I'll just add that, and this is to pick up on an aspect of the question as it was asked. It says that media can't publish names. You can, as long as you have obtained information legitimately, either through a public record or through a source, you have a constitutional right to publish names. That doesn't mean you should. I mean, obviously there are reasons why you wouldn't want to. But just because something is deemed confidential for purposes of the UJS public access policy or even a seal does not limit what you can publish.
That's a great point, Melissa. And Rachel, I see that you're still struggling with the slides. You can see these slides afterwards. It's okay for Pennsylvanians for Modern Courts to send them out. I don't have a good technology hack, but I'll try to explain what's on the screen in case you can't see it. So we're talking about court records are open to the public. You do not need a public records request. One thing in Pennsylvania that is up on the screen here is Pennsylvania's clean slate law and your state may have some version of this, but this has created some confusion in courtrooms throughout Pennsylvania. Not courtrooms, custodians of court records. So, okay, here we are onto the clean slate law. The clean slate law limits public access to certain convictions and criminal case records. Records are automatically, and I'm going to do air quotes for those of you who are listening and not watching, clean slated. This is a term that has come about as a result of a law. The legislative intent was legislators felt that for persons who had served their time and were no longer under supervision for more minor crimes, that they should have the opportunity to look for jobs and other opportunities without their criminal records coming to haunt them. So essentially, this law puts off limits from public view as certain crimes. So eligible individuals here in Pennsylvania for 10 years have to be not convicted of an offense punishable by a year or more in prison. And also they would have to complete all court-ordered obligations. Currently, the only thing eligible in Pennsylvania for clean slate or limited public access would be low-level misdemeanors, summary convictions like a disorderly conduct, and charges not resulting in convictions such as dismissed, withdrawn, or null prost. And one word there just to note is, let's say you're covering a person who's running for public office and she's charged with DUI and some other charges. The case gets dismissed, it goes away. If you haven't saved it or downloaded the court documents, you won't be able to find them again in Pennsylvania if the case was dismissed. So this law has caused, as I said, a lot of confusion in some of the court filing offices and also some difficulties with getting records. And Melissa, are there any questions in the chat? I'm not on that screen that are relative to this.
It's difficult for me to see.
Okay, hang on. I just
So
saw.
I can tell you, so hi,
Yeah.
it's Debbie. So there's a question, if you don't have the resources to get counsel involved, like what do you recommend to get access to sealed records?
That is a great question. Call our hotline at the Reporters Committee. If you're in Pennsylvania and you're a P&A member, call Melissa. But let's say that you can't, it's quick. Something's happening right then, and the courtroom is sealed, or you need a court record. You can ask the court administrator. You can ask the president judge. We have those in Pennsylvania. Try to get the highest court official and make your case. I don't understand. Why is this sealed? I need it. And one of the things we talk about sometimes is the power of the pen. If you're not able to get counsel involved, sometimes writing about it is helpful to explain, the efforts that your news outlet went to try to obtain this record. But sometimes, unfortunately, the only recourse is getting counsel and filing a motion to intervene and unseal. We recently had to do that in State College, Pennsylvania, where Penn State University went to court and sealed records, and we represented 3 news outlets to open up those records. So sometimes I'm sorry to say that a lawyer is probably, your best bet. And thank you, Ganita, for posting in there the hotline. And I see, Jessica, your story that you're working on about the 1972 cold case. Let's hold that to the right to know section. Here, this is really important. So we're onto the slide. We have heard from some journalists in Pennsylvania that felony cases, these are major crimes, that reporters are being told they cannot have access to the records related to the felony because maybe some lesser charge was withdrawn or dropped. It's important to know that none of these crimes involving danger to persons, crimes against families, firearm offenses, none of them are eligible for clean slate. No felony is eligible for clean slate. And then there's a variety of other crimes, some particularly sex crimes that would not be eligible for clean slate. So we'll go to the next slide. Just a note on this, in Pennsylvania, clean slate is an automatic process. The Administrative Office of Pennsylvania courts, the state police, and county judges are involved in this process. If information in a case has been clean slated through that whole laundry list, then you will not be able to see it. But if there's something in there, such as an affidavit of probable cause that doesn't relate to a dismissed charge, you should still see it. This is an area where we've seen a lot of confusion. So only information related to clean slated charges should be restricted. You should have access to the rest of it. And this follows up on the professor's talk from earlier when he was talking about suppression motions. Debbie talked about some motions in her discussion about civil cases. Pretty much everything in that file should be open. If it's in the courthouse, if it's stored within a filing office, you should be able to get it, unless clean slate or some other restriction applies, such as a sealing order based upon good cause shown on the record after an opportunity for folks to object. So go ahead, Melissa.
So I just wanted to mention, in addition to clean slate, there are other statutes and policies that may impact what you can and cannot access from Pennsylvania courts, including the Pennsylvania's Unified UJS Public Access Policy. So that policy determines the level of access based on the method where you're accessing. You will get the most access if you physically visit the courthouse and request access to records. You will get the least amount of access online. So just bear that in mind. And we have got a link here out to the UJS Public Access Policy, in addition to the Public Access Policy itself, which makes certain categories of information non-public. So for example, the attorneys have to file certain information like bank account routing numbers, social security numbers. That has to be filed on a confidential information form, which you won't have access to as a member of the press. That public access policy governs what you can get. But again, the level of access is always best at the courthouse, which kind of stinks because we're a big state. And if you're in Philadelphia covering something that's happening in Erie County, you either have to find someone who's willing to work with you at the local, in that locality, or you have to get in the car and drive. So just remember that access is best at the courthouse. Attached to that UJS public access policy, you will also see a chart of limitations that's kind of referred to in the policy, and that outlines many of the statutes in Pennsylvania that limit what you can and cannot access. So for example, when Paula mentioned access to juvenile dependency hearings and delinquency hearings, there's a statute that deals with that. There are statutes that deal with minor victims of physical and sexual assault. There's a statute that deals with victims of sex trafficking. So for example, you wouldn't get their names in many situations because the statute says you wouldn't. So I recommend, if you're planning on covering the criminal court system or the civil court system, for example, you check out the UJS public access policy as well as the attached chart.
Thank you, Melissa. And thanks, Sasha, for dropping that in the chat. So we've talked about judicial records, and we're going to flip over to a state public records request, in this case, Pennsylvania, the right to know law. But before we hit that, we've already talked about you can walk into the courthouse or use one of the courthouse systems to obtain records. That's not a right to know law request. What we've got on the screen right now are links to State Treasury, PennWatch, Pennsylvania Department of State, Pennsylvania Disciplinary Board, Pennsylvania Ethics Commission. These aren't right to know requests either. These are examples of places where data can be readily found. You don't have to file a right to know law request to get this information. It's there. For instance, the State Treasury agencies are supposed to post contracts greater than $5,000 to the e-library. Now that doesn't always happen. There are some bills attempting to give some teeth to the section of the right to know law that says state agencies must post contracts, but you can go into that e-library and search for a vendor. You can search for a state agency. If you wanted to look at the Pennsylvania State Police, you can find whatever contracts they've uploaded. PennWatch gives you WATCH gives you access to employee salaries and information about the complement of employees per agency. Pennsylvania Department of State has a host of information ranging from business, nonprofit, masseuse, funeral director licenses, doctor licenses, nurse licenses, lobbying. There's a whole ton of information on Pennsylvania Department of State, campaign finance. Pennsylvania Disciplinary Board, a great way to find a lawyer's phone number. If you're on deadline and you need to track down a lawyer for a story, you can type in their first or last name, look them up. And then the Pennsylvania Ethics Commission, it requires statewide candidates or officials to post statements of financial interest for the preceding year. There's also rulings and decisions of the Pennsylvania Ethics Commission. So what we just talked about, court records and sources of information that are posted proactively, no public records requests needed. Now we're going to flip over and Melissa's going to talk about our state right to know law here in Pennsylvania.
Sure. So the right to know law as it exists today was enacted in February of 2008. It became effective in 3 different stages, but it's been in effect now for over a dozen years. There are some significant provisions of the right to know law that I want you to be familiar with. Now, prior to the implementation of this new law, and I'm saying new with air quotes here because it's not really new anymore, we had one of the worst public access laws in the nation. This new right to know law was a sea change. It's supposed to act as a sea change. As part of that sea change, we have the legislature recognizing the presumption of access, which means that the records in possession of a government agency are presumed to be public, and the burden of proof for denying lies with the agency. The definition of record and public record were significantly expanded. It now covers the General Assembly and the courts, although I'll talk a little bit more in detail about that. I will mention for the courts, although the text of the right to know law itself says the courts are covered, the courts don't really acknowledge that. They operate with regard to access to their financial records, how much they get in funding, how much they spend under what's called Pennsylvania Rule of Judicial Administration, Rule 509. That's their equivalent right to know law procedure. So just be aware that you wouldn't file a right to know law request with the court system asking how much the judges are making. You would file a Rule 509 request. The General Assembly is covered by the right to know law, but it's covered in a more limited fashion. If the record you're looking for does not fit into the definition of legislative record, then it's not going to be reached by the right to know law. The executive level agencies, the executive branch agencies, the governor's office, all the state level, the Department of Health, the Department of Motor Vehicles, the Department of Transportation, boroughs, counties, townships, those are all fully covered by the right to know law. It reaches all of their records. The right to know law also created the Office of Open Records. And in addition to the list that Paula just shared, the Office of Open Records has a very informative website that's just packed with information on right to know law, all the decisions it's made, the decisions from various district attorneys on different areas of the law. I recommend checking them out if you have any questions on right to know law. Email requests are expressly permitted, and I recommend them whenever possible because they're the easiest to track from a time perspective. With regard to time, agencies have 5 business days in which to respond to you, and it must be a response in writing. Please be aware, many agencies, as a matter of practice, invoke a 30-day extension. It's not supposed to function that way, but there's no penalty for them for taking a 30-day extension, even if they don't really need it. We're working to change that legislatively, but they have to get back to you within 5 business days. Most of the times they will say, many times they'll say we need another 30 days because of various reasons, but it's 5 days. And if they don't get back to you within that 5 days, your request is deemed denied and you have a right to an appeal. The right to know law reaches contractors that are performing governmental functions and the records directly relate to that function. That was not possible under the prior right to know law. State-related institutions, which are Penn State, Pitt, Temple, and Lincoln, they are covered, but on a very limited fashion. The PASHE schools, the state system of higher education schools like Kutztown, Slippery Rock, Bloomsburg, they're covered fully as an executive agency. All of their records are presumptively public. The state-relateds have to file very limited annual 990 information and their highest 25 salaries and the highest 25 salaries and the salaries of their board members, but that's really it. It created an online searchable database for state contracts, which Paul already mentioned. Now there are 30 specific exemptions for various categories of records under Section 708B. These are all the things that the legislature said these records can be withheld because there's a good reason to withhold them. But I will note, none of these exemptions are mandatory. There is nothing in the right to know law that makes a record confidential. The right to know law is a public access statute, and it sets the floor for public access, not the ceiling. Some agencies take the position that if there is an exemption that applies, they have to deny access based on it, and that is both a misunderstanding of the law and a misapplication of it. Even if an exemption applies, the right to know law allows agencies to provide access to that record as long as no other state or federal law or court order make it expressly confidential. And that's because the law recognizes that even an exempt record can serve the public interest. And in many cases they do. So even if you know you're requesting an exempt record, make a public access argument along with your request to prove, to show, to illustrate why public access is important. You get most access to financial records and aggregated data. Most of those 30 exemptions don't apply to financial records and aggregated data. So who's covered? Like, who's covered by the law? Commonwealth agencies, local agencies, legislative agencies, and there's 18 categories of legislative record. Judicial agencies are covered as well, although we already talked about Rule 509. So what's available under the law? The right to know law doesn't distinguish between formats. If it's information, regardless of physical form or characteristic, that deals with the function of an agency, it's going to be presumptively public under the law. It also doesn't distinguish between agency and personal email accounts or agency and personal social media accounts. For example, I get a lot of questions about whether or not a record is reachable if it's on a public official's Gmail account. And the answer is yes, it is. It doesn't matter if they're using a government account or a personal account. What matters is the content of the record. And if the content of the record deals with agency business, the right to know law will reach it. The key consideration is it a record? And if so, is it a public record? The answer to is it a record is typically going to be yes. It gets more complicated when you get into is it a public record? So like I said before, a record is any information that's regardless of physical form or characteristics that documents a transaction or activity of an agency, and it's created, received, or retained pursuant to law or in connection with the agency's business. And it's the definition, if you look at it in section 702 or 102, it's broad. It reaches just about everything, including electronically stored data, metadata, for example. We've had court cases determining metadata that is internal to a document or attached to a document is reachable under the right to know law. What's not a record is any information that's made confidential by some other law, regulation, or court order, or information that's protected by a lawful privilege. So the one that I see most commonly is the attorney-client privilege. If something is subject to some other law says a record is confidential, the right to know law will fall away. That other more specific law will be the guiding principle here. Similarly, court orders. If there's a court order that makes a particular record non-public or confidential, the right to know law public access provisions will not apply. Now, with regard to court orders, we've already mentioned just because a court order is sealed, just because a court order seals something doesn't necessarily mean it's been sealed up upon a showing of good cause. And this happens pretty often with settlements that involve public agencies. So it's pretty common for the parties of a settlement to agree to a confidentiality provision and the court to sign off on it. Those confidentiality provisions are unenforceable as a matter of Pennsylvania law. So that may mean you may need to get a lawyer involved to intervene in that underlying case to attack the seal order and get it declared or get it opened up before you can get access to it through the right to know law. But just remember, confidential by law, there's not really much you can do about that. Statute says something. Privilege is debatable. Just because someone says something is attorney-client privilege doesn't necessarily mean that it is. There are standards that attach. And court orders, many are sealed for good cause, but not always. So just bear in mind that just because something is sealed doesn't necessarily mean it's not public. Paula, did you want to weigh in?
Yeah, I just wanted to jump in and say, we have seen instances where a reporter has filed a right to know law request seeking a settlement agreement. That's money, money paid out by the government is one of the most accessible categories of information under the right to know law. And then the agency will say, oh, sorry, you can't have the settlement agreement. It's sealed by court order. That's a really dubious technique. We're actually litigating a case in the Middle District of Pennsylvania that has a similar fact pattern, and I can post that in the chat. But yeah, if it's a settlement agreement and it's a payout by the agency, that should be accessible. There may be a few reasons why some things could be redacted, but mostly you should get that record.
And it's not just to do with money either, although money is often part of settlements. Sometimes a settlement is reinstatement to a job or the installation of a gender-neutral bathroom or a nursing facility for pregnant lactating women. There are non-financial aspects that are public in the same way that the financial aspects would be as well.
And Melissa, I just see two questions in here.
Okay.
One is from Susan Phillips about pre-decisional. I think we're going to get there. Melissa's going to talk about some of the exemptions, and then Boris wants to know what happens if an organization that you request information from does not respond after the initial request is filed. Got an initial response that gave them 30 days, but nothing after that. So time frames are really important, and it sounds like that is going to be a deemed denied. But Melissa, do you want to, we'll get to Susan's later, I think, but do you want to say
Sure.
anything about timing now?
Sure, timing, like I said, they have 5 days to respond. They can take additional 30 days in some circumstances, and you can give them as much time as you want. But once that deadline comes and goes, whether it's the 5, the 30, or something you've agreed on, once that comes and goes without a response from the agency, the request is deemed denied and the clock begins to tick against the requester. You have 15 business days in which to file an appeal to the Office of Open Records, typically, to preserve your legal right. And once you file that appeal, the agency will have to participate, or they'll get a default judgment from the OOR entered against them. So yeah, if you have an agency that has failed to answer, I mean, I recommend reaching out and saying, hey, look, did you just forget about this? Is somebody on vacation? You know, whatever. But bear in mind that once that deadline passes, you have 15 business days in which to file an appeal to the Office of Open Records. So with regard to pre-decisional deliberative exemptions, that is one of the most commonly cited bases for denial. There are 30 here, and I'm not going to go through all of them because we just don't have time. With regard to pre-decisional deliberative information, the courts, there's a very specific test that goes along with pre-decisional deliberative. It's got to be internal to the agency. It's got to be deliberative in character, which means it can't be purely factual, and it's got to predate the decision. Where pre-decisional deliberative is typically most commonly thrown aside is where an agency decision is not actually deliberative in character, so it's purely factual, like data, for example, or it's external to the agency. If it's shared with a third party, like a business entity, for example, it's no longer pre-decisional or deliberative in character because it doesn't meet the requirements of the test. There may be other exemptions that could apply, but records that are shared with third parties are by definition not pre-decisional or deliberative because they've been shared with a third party. But like I said before, even if a record is exempt, ask for it anyway, because the right to know law sets the floor for access, not the ceiling. Agencies can, and in many circumstances should, provide information in the public interest. So how do you file a request? What does the law require? These are pretty self-explanatory. I recommend you use the Office of Open Records. The Office of Open Records has a form on their website. You just fill it out. The biggest stumbling block in filling that out is being non-specific. This is the most common stumbling block for journalists that I hear about. There's a 3-part test for specificity that the agencies, even though they're not supposed to go through this as a standard practice, they do. They say, if you don't meet all 3 of these factors, we're going to deny you for specificity. It's my advice, even though they shouldn't do that, they actually do. It's my advice that to the extent you can hit all 3 subject matter, all 3 parts of the balancing test for specificity in your request, you absolutely should. So you've got to have a subject matter of the request that's got to identify the transaction or activity of the agency. The scope of the request has to identify a discrete type of document, groups of documents like type or recipient, and that there should be a time frame, and it should identify a finite period of time. The shorter the time frame, the more flexible the other 2 factors will be, and none of them are dispositive. We've had cases where there is no time frame. We've had cases where there is no subject matter that have been found to be specific. But to the extent you know these things, you should be as specific as possible to avoid the specificity denial, because that just wastes your time. You have to take 30 days to file an appeal, then go back and you may have to go back and restart the right to know law process. So be as specific as you can at the outset so that you don't hit that stumbling block. Again, here's some tips on specificity. Don't go on fishing expeditions. If you don't know the record you're looking for, you're not ready to file a right to know law request. You don't need to use magic words or the same terminology that an agency uses, but you should be able to explain to them what you're looking for. Records that show this, records that illustrate that. Don't ask questions. They're not required to answer your questions, and they can ignore that kind of request, right? They can just say denied. We don't have to answer your questions. Always request copies of records or ask to inspect them. Whenever possible, use party names and or positions to help define your scope. Be wary. I do not recommend requesting a list or other compilations unless you already are positive that they exist, because if they don't already exist, the agency doesn't have to create them for you. Be also wary of providing only keywords or search terms without a corresponding subject matter. And I know it seems like counterintuitive, right? That if you give them very specific keywords or search terms, you shouldn't have to give them a subject matter, but there have been cases where keyword only or search terms only without a subject matter have been determined to be non-specific. And avoid using legalese, right? You don't want to use something like any and all or including but not limited to, because by definition, those are non-specific, and it's just kind of begging for not a specificity denial. So once you've gotten your request narrowed down, you know what you're looking for, you've gotten your specific request put together, where do you file it? You have to file with the agency's open records officer, and each agency has to have a specific contact person who's appointed to deal with right to know. Their contact information has to be posted on the agency's website if they have one. The OOR also maintains a list of agency right to know law officers, but that is notoriously incorrect because it falls to the agency themselves to provide updated information, and that doesn't always happen. I recommend to journalists that they contact the agency directly to confirm the right to know law contact information prior to submission, just to make sure it's going to the right person, because if you send it to the wrong person, they don't have to answer it. I recommend you submit by email whenever possible, because the deadline for their response, that 5 business days, that doesn't start until the right to know law official actually receives the request. When it hits their inbox, for example, if you drop something off in person or by mail, you don't really know what's happening inside that agency unless you're handing it right to the right to know law official. So agencies are big, many of them are big, some of them have many people working. There are internal processes that may make it difficult to track that 5 business days. It's not when you submit it that the clock starts, it's when the agency actually receives the request. So email is the recommended means. The agency has to respond, like I said, within 5 business days. Well, it's as promptly as possible under the circumstances, but no longer than 5 business days. So if you hit that 5 business days and you haven't heard from them, you are deemed denied, and the clock again begins to tick against you. Within that 5 business days, the agency has to do one of 3 things. They have to grant the request and provide you a fee estimate. They have to deny the request and provide a legal basis and the appeal method, or they can request up to 30 calendar days under Section 902 and explain the reason for the delay, the date that a response is expected to be provided, and an estimate of applicable fees. So that if that 30-day extension means it happens more than it should. If you get hit with a 30-day extension, don't be surprised. There's nothing you can do to challenge that. If you have an agency that does it routinely and habitually for simple things that should be readily available, like meeting minutes, for example, let us know. That may be something that deserves more attention. So if your request is denied or deemed denied, you have 15 business days from the mailing date of the denial or the deemed denial to file an appeal. Most appeals from local agencies and Commonwealth agencies are decided by the Office of Open Records. There are some narrow exceptions to that. What I hear about from journalists most often are local agency denials, like a county or a school district or a police department denying based on the criminal investigation exemption. In that case, the appeal is decided by the district attorney's appeal officer. The independent agencies that are listed there, the Attorney General, the Auditor General, State Treasurer, they have their own appeals officers as well. But even if you're dealing with local agencies, the Office of Open Records recommends that you file the appeal with their agency anyway, and they will get it to the appropriate place. I recommend filing with both the local agency appeal officer as well as the Office of Open Records. It doesn't hurt to be more thorough than necessary, and you can always withdraw any appeal. Yes, Paula, go ahead.
This is now that you've got criminal investigation up on the screen, this is a great time. Jessica has a question. Any exceptions to homicide investigation exemptions, a cold case open but several decades old? How accessible is something like that, Melissa?
It's not accessible at all. Unfortunately, under Pennsylvania's law, there is no temporal limit to the criminal investigation exemption. Once it's investigative, it's always investigative, even if the investigation has been closed for decades and everyone involved is dead. We're trying to change that legislatively, but there is no means of access under the right to know law. There's no right of access under the right to know law. Now, the facts that you've explained may make it more likely that an agency will share with you under Section 506. That's the section that allows them to share an exempt record in the public interest. So that's a situation where you'd want to make a public interest argument to the agency. But if the agency denies you, the law does not enable you to get access, even if the investigation is closed. And I'm sorry to have to say that. So do you want to hop on to Act 22, or do you want me to talk about that, Paula?
Okay, so Act 22, we talked about earlier what is not a public records request, judicial records, information that's presumptively out there. Want to make sure that those of you who are in Pennsylvania know that a body camera footage or a request for audio or video from law enforcement, that is not covered by the right to know law. Up until 5 years ago, when we had a really great decision from the Supreme Court of Pennsylvania granting access under the right to know law to a motor vehicle recording video. And the Pennsylvania Supreme Court said, yes, you may be able to get portions of this video under the right to know law. The legislature then passed this law that said, if you want audio or video from law enforcement, you do not go through the right to know law. You go through an entirely different process that is honestly quite convoluted, difficult, expensive, and frankly, we don't know of too many people who have really had success in getting these. We're currently litigating a case out of Cumberland County. Kunita is litigating that with me. Maybe she can drop in the chat a link. But essentially, if you want this video, you have to put in the request within 60 days of the incident. It must be delivered in person or by certified mail. So note the difference with Melissa was talking about the right to know law, emails fine, fax, snail mail. Here, two methods, 60 days. Under the right to know law, the identity of the requester doesn't matter. It could be somebody who's nosy. It could be a reporter. It could be my mom. It doesn't matter under the right to know law, and the agency doesn't have the ability to ask about that. They're actually not permitted to. Here, you have to say who you are, why you want this record, what your relationship is to the record, and some other information such as if the video was recorded inside of a residence, identify those who are present if possible. So these things are really hard. In 5 years, we can think of just a few cases that have gone up on appeal. The appeal goes to the Court of Common Pleas, where there is a weighing test. The Office of Open Records has useful information and a model request form on their website, but we just haven't seen a lot of success here. So if you have filed an Act 22 request for law enforcement audio or video and you met with success, we'd love to hear about it. I think that's about all there is to say on that topic, unless there was anything in the chat. Susan had a question, not about this. What about an investigation that is not criminal? For example, the PUC does pipeline incident investigations and always say they can't give any information until it's concluded, which can take several years. These are the two main ones that are really stumbling blocks here in Pennsylvania. We talked about the criminal investigation exemption. There's no time limit. And then the non-criminal investigation exemption. And Melissa, I don't know if you want to say a word about that. And I'm going to drop chat a PUC case for those of you who are interested.
Yeah, with the PUC, depending on what type of information you're talking about, certainly the right to know law is going to be the first level of access, and the non-criminal investigation exemption is very restrictive. So there's no right to access even if the investigation has been closed. There are some exceptions to the rule. So for example, if an agency if the PUC enters a fine or a punishment or revokes a license or enters into a settlement agreement, those are all going to be public. Specifically with regard to the PUC, There's a separate, more specific law. And remember, the more specific laws always will supersede the right to know law. There's a specific law that's the Confidential Security Information Act, CSIA, that often gets involved in PUC appeals because certain information is deemed confidential security infrastructure. It's deemed sensitive and potentially dangerous to release. So with regard to PUC, that's a separate law you may want to think about. And there's some unfortunate case law holding that if you get into a position or you get into a case that involves that more specific law, the Office of Open Records doesn't have jurisdiction. You'll have to go to the court, typically the Commonwealth Court, because the PUC has original jurisdiction for the Commonwealth Court.
And I put in the chat a case we filed, a friend of the court brief on involving PUC. That went up to the Supreme Court where they essentially said, no, the CSI controls here. And I want to make sure we try to stay on track with our time. So Melissa, if you want to speed advance. Oh, good. Okay. So speed advancing. So we've talked about state level right to know requests, focusing today on Pennsylvania. But again, I can't stress enough, you're going to find tons of information at our Reporters Committee guide for all the states. And maybe one of you can drop that in the chat again.
Paula.
Yeah.
I'm sorry to interrupt. Before we hop off of right to know, I didn't say this and I say it in every training. You do not always have to start the process with a right to know law request. Call the agency, reach out to them via email. Informal will typically get you more access than under the right to know law. The right to know law is there for when you can't get the information you're looking for. My recommendation is always try to get access outside the context of the formal right to know law. If it doesn't work out, that's fine. The right to know law is there to provide you access when informal doesn't work. But especially if you have an ongoing relationship with an irregular relationship with an agency, and many of you as press members will, call them first. Go through the press office if you can, or the direct contacts at the agency. You can get more and oftentimes better information that way than through the right to know law, which will automatically be routed through an attorney.
Okay, now we're going to, and I see a couple chats. I'll get to some folks after this, but speed FOIA, Freedom of Information Act. It's the federal law that provides access to information. FOIA Wiki is where you want to start here. This will give you tons of information. It's at the bottom of the screen, but it essentially will go through what agencies are subject to FOIA, and there are different tests about which federal agencies might be subject to FOIA, what might not be subject to FOIA. And our attorneys in the DC office do a lot of training about FOIA and a lot of litigation around the FOIA question for news outlets throughout the country. So if there's a particular question, oh, thank you, Debbie. If there's a particular question about FOIA, I would definitely say start with the FOIA Wiki. And then if you have more questions, you can contact our hotline. Sometimes reporters will want to know, let's say here in Pennsylvania, there's a dual jurisdiction. We have the State Department of Environmental Protection and then the Federal Environmental Agency. You might want to try both. So you try a FOIA for the federal records and you try a right to know for your state records, but there can be crossover. If you flip to the next screen, Melissa. So the FOIA Wiki, there was a picture there just showing what it was. Just like the right to know law, it's pretty easy. And also similar to the right to know law, you want to put your request in via writing. You want to reasonably describe the records you're looking for, and you're going to submit the request. And specificity matters. So for instance, in the example of DEP and federal environmental records, you want to make sure you're carefully thinking through what records might the feds have versus what records does the state have under the right to know law, and put that in. On the next screen, Gunitha could probably talk about this. There's a different timeline under FOIA than there is in the right to know law. When our quote unquote new law was passed, the legislature really wanted to see some prompt resolution, although many of you know, that prompt for some cases in Pennsylvania can mean 5 years later. With FOIA, there's a different time frame. You can request expedited processing, but it's rarely granted. In order to get that, there must be a showing that there's urgency to inform the public concerning actual or alleged federal government activity, and you have to include a statement for the reasons. There's also fees. So in Pennsylvania, fees are different, and we could talk about that in a different program, or check out the OOR website. They have a.
So I'm going to interrupt you guys. I'm so
Yeah.
sorry. You have done an amazing job,
Oh.
and I very much appreciate it. And I'm sure you have more to tell
Yes.
us.
I think that, yeah,
But
if,
we have
there it is. That's the last slide.
Oh,
That's us.
excellent. Okay. But thank you. And as we said on the chat, we will circulate these slides for everybody, and the speakers I know will be more than happy to hear from you. But we are going to move on to our last panel. So sorry for taking everybody's break away. But I just felt it was more important to get the information that they were conveying, as it was really a lot of information that we learned. And our next panel, we welcome and thank you so very much, David Bodney, who is senior counsel at Ballard, Spahr, and Judge Peter Swann, who's from the Arizona Court of Appeals. Thank you both for joining us. And we've had a long morning, but it has been so informative and wonderful. And we have about anywhere from 130 to 150 participants, so you both know. So thank you, and I'm handing it off to you.
Well, thank you, and good morning. I'm David Bodney. I'm here with my friend of 30 years, the Honorable Judge Peter Swann, and we thought we might address this last question or topic of the morning in a kind of colloquy with one another. But we want to start by thanking all of you for being here with us today. And we hope we can shed some light on a very large topic, disinformation and access to the news. And I thought I might just kick it off in this very broad fashion. If we've learned anything over the last 4, 5, 6 years, we've learned how essential to democracy the judiciary and journalists are to this experiment in ordered liberty, our democracy itself. There could be a number of reasons for that. We know that judges and journalists share at least one thing in common, and it's vital: their fidelity to the facts. In the courts, those facts are evidence. In the newsroom, those facts become news. And I was taken by a couple of statistics, and I'll try to do this very briefly. If you've heard them previously this morning, I apologize. There was a poll conducted by Gallup just last month, before the Supreme Court decided the Dobbs case, reversing Roe versus Wade, before. And Gallup found that the public's confidence in the United States Supreme Court has fallen to the lowest level in 50 years. Only 25% of US adults say they have a great deal or quite a lot of confidence in the Supreme Court. Just the year before, that number was at 36%. At the same time, last month, the Reuters Institute conducted a survey about news. And Reuters found a drop in trust in reporting in the United States to the lowest point yet recorded, at 26% of the population. And we could drill down a little bit further into those numbers, like 42% of Americans actively avoid the news at least some of the time because it grinds them down or they just don't believe it. 15% of Americans said they disconnected from news coverage altogether. Those numbers are even higher among folks who participated in this survey in the United Kingdom and Brazil. People who self-identify as being on the right wing of the political spectrum think the news is untrustworthy or biased. On the left, they feel overwhelmed or just powerless to deal with events in our society. And so we've got only 25% of the American public saying they have high confidence in the Supreme Court, just 25% saying they have confidence in the news. So I'm just wondering, when confidence and trust in our judicial and journalistic institutions are so low, is it any wonder that disinformation spreads so far and wide? Judge Swann, what do you make of that?
Well, I think there are a lot of reasons for disinformation and its spread these days. Can you hear me? Just making sure. Okay. There's a lot of reasons for it. As I listened to the statistics you were floating, it occurred to me that there's an opportunity for the news and the courts to enhance public confidence and hopefully thereby do away with some of the disinformation floating around by working together more. You know, the U.S. Supreme Court is a special case. I will readily admit that, you know, I've devoted now the last 20 years of my life to the judiciary. I have very little confidence in the U.S. Supreme Court. Whatever you might think, whatever side you might fall on the choice issue, Roe v. Wade was certainly a very debatable decision in the way it was constructed, and yet the court acted with the help of the Senate in a way that absolutely communicates a raw political power grab. That's not what the court is supposed to do, and I'm afraid we're going to look at the Supreme Court that way for quite a while to come. But remember, the Supreme Court is only 9 justices, and I expect it to remain only 9 justices. They handle fewer than 100 cases a year, and the rest of us out there are doing very differently. In Arizona, we have a judicial performance review process, which requires us, say we sentence someone to 10 years in prison, we hand them a survey and ask how we did. And we do that at the appellate level with all of our cases. The statistics there are markedly different. We usually score in the high 90s, or not in the low 90s, in terms of public confidence when you look at people who have actually witnessed what we do. And by we, I'm not just talking about my court. I'm saying we who are not celebrity judges, we who just, you know, go to work and decide cases. To the extent that the press can cover what the courts are actually doing, I expect it will enhance people's confidence in the way at least some of their government works. And I expect that the way the Dobbs and other Supreme Court cases have played out are going to result in an increased public attention toward local officials, local races, state legislatures, state courts, where we chop wood, and we do so in a fairly mundane fashion. And I would suggest to you that a mundane court is a good court, is a healthy court. It may not always be the most headline grabbing, but that's where the opportunity lies to actually communicate to people what's really going on in a way that enhances confidence both in the press and in the courts.
So, Judge Swann, it occurs to me that when reporters reach out to the courts or officers of the court for comment about their cases, the most frequent comment is no comment.
No comment, right.
We'll answer, you know, in our papers, we'll answer in court. In fact, when the Associated Press just this last week went to the United States Supreme Court to ask, hey, you had this major leak before the Dobbs decision, and the next day you announced there was going to be a major investigation. What's the status of that investigation? Did you hire outside counsel? Are you working on an investigation now? Can we expect anything? And the answer from the United States Supreme Court, like the lower courts and judges who, lawyers who appear before them was, yeah, no comment.
Right. Well, that's ironic because the United States Supreme Court is the only court in the nation that doesn't operate under an ethical code. And if you have any doubt about that, I can point you to a few examples. But the rest of us operate under fairly strict ethical codes that often prevent us from commenting, but not always. And I would encourage any reporter to reach out to any court personnel at any time and just give it a shot. When a case is done, I can talk about it, and I'm happy to. And I do talk to reporters because I have yet in my career to see a reporter try to report on a case in a slanted or incorrect way. But I have very rarely in my career seen a report come out that accurately describes what happened in a case.
So what's the disconnect there?
Well, I think the disconnect is a lack of understanding of what's actually going on in the court. What people see, and this is exacerbated when they read the news, people will see a case, they will form an opinion about that case just by a one-sentence description, and then they'll see what the court did and make assumptions about what happened in between. The reality is that what goes on in court is not such a direct line. So many cases of public import are decided on issues other than the merits. They're decided on issues other than what the public cares about. We have to ask, has there been a cognizable case even stated, and can we listen to the facts, or does the law require us to throw a case out? Does a litigant have standing? Is that litigant the right person to bring the case? I would say half of the constitutional cases are thrown out on those grounds alone, and the temptation is to infer that the courts have it in for such and such a cause or such and such a viewpoint. But courts that are doing their jobs actually are just applying the law, which does impose a certain number of obstacles to getting a case heard on the merits. That's not necessarily a bad thing either.
So we could say that the court has it in for the maintenance of the status quo.
Well, I like to say that the judiciary is the boring branch of government. And what our job is, if any of you are Spinal Tap fans, between fire and ice, we are the tepid water that keeps the system stable. We are supposed to maintain the status quo until the status quo is no longer viable. That's when you hear about principles like stare decisis, which are often misunderstood. So I think stability, predictability is what the courts strive to deliver. And I think if you look at the vast majority of the thousands and thousands of judges working in our state and federal courts, you'll find that that's exactly what they strive to do. It's frustrating sometimes for me and my colleagues not to have as ready a voice when we speak to the press, but most of us will do our best within the ethical constraints we face to do so, because we know that reporters are really doing their best to inform the public, and they're trying to inform the public about something so complex that a bunch of lawyers couldn't figure it out amongst themselves, and they had to come to court to figure out a problem that is inherently difficult to understand.
So what else can the courts be doing to enhance public understanding of their tepid mission?
Well, I mean, I know that this is a Pennsylvania-centric presentation, and I've given presentations with some of the justices in Pennsylvania who I think take an attitude very similar to that in Arizona, which is that openness is a good thing. I don't know all the rules in Pennsylvania. I know that in Arizona, virtually all of our court proceedings are recorded, making the whole cameras in the courtroom debate a little less important, because all of those recordings are done in 4K and they're downloadable. So that's a start. Ensuring that everybody has access to every proceeding is a good start, and ensuring that we have PIOs who are informed enough to give meaningful comment on the background of a case is important. I would also say that reporters could do themselves and the system of justice a favor by attending some court proceedings that are not special, just to see how it works, just to get to understand the flow and the dynamic of a court proceeding and see what we do day in and day out. Go spend a day in family court and watch what the courts are really doing. When you think about what state courts do, we really are not deciding abortion cases more than once or twice in a career, if that. What we are deciding are cases that affect real people's lives day in and day out. And I do believe that there is public interest in what are we doing all day? Are we out there just crusading for our own polarized political agendas? We're really not. What we're doing is deciding cases that nobody cares about except the litigants, but to the litigants, they're the most important thing in the world. If that sort of process were more at the forefront of the public consciousness, I think that in confidence in the courts and in the press would be enhanced.
Mm-hmm. Well, I guess I'm wondering a little bit more about the opening the aperture into the process. And if we just look at the last week of the most recent Supreme Court term, we saw cases decided affecting society's ability to deal with global warming, guns in New York City or their regulation, the right to choose or abortion, and free expression and religion in the Kennedy case, some big decisions. And we've seen over the last year, just about in every state, lots of big cases filed with respect to the election. Who won? Was there fraud? This kind of thing, and so on. Big issues. I guess what I'm wondering is, why can't the public see the deliberations that occur among appellate court judges when they decide whether to take a case or who will be writing the opinion? Kind of what the pros and cons on about standing and this and that, so that we have a better appreciation of how your decisions get made.
Well, I guess I would throw it back at you and say, why don't we have a live stream of what happens in an editorial meeting? There has to be some room for free debate, for people to change their minds, for people not to be afraid to look stupid, and to come to an understanding without being on TV all the time. The human beings just aren't capable of being their best selves when they're on TV. I think that's almost universally true, unless your best self is singing or something like that.
I'm having a hard time at this moment, Judge. So.
Well, there you go. Yeah, I mean, I can't see all the eyes that must be rolling to what I'm saying.
However, if I may interrupt you once again, many of the newsrooms are open to the public, and members of the public can view the process by which a newsroom decides what stories rather to cover.
Yes, but when you look at what winds up on the cutting room floor, there is a recognized First Amendment privilege for the press, and I think that makes sense, because what that recognizes is that all people need a little bit of privacy to form a statement, whether that statement is a statement about the news, whether that statement is a statement about the law or the facts. Our internal processes of debate and our attempts to persuade one another, often just by dint of human nature, need to be done with a little bit more privacy. We don't watch jury deliberations for the same reason. It is just not reasonable. Well, we could. We could, but is the value of public access to every nuance of the process greater than the value of getting a result that has integrity? I would suggest not. And I would also suggest that unless we are prepared to sit down and watch the entire thing so we understand the context, the prospect for misinformation exists at an even greater level when you zero in on a few out of context moments in what is supposed to be a private debate. So I am very much in favor of open government and open courts, but there are times when we have to have private conversations. We have private conversations with our attorneys. We as judges have statutorily protected private conversations with our law clerks. We struggle to reach an understanding of a case, and as I often tell my law clerks, most cases are actually very easy to decide. What's hard to do is to understand the case. It's easy to decide the wrong case correctly, in other words. And as we come to that understanding, we make mistakes. We revise our thoughts. We do, and if you're only going to look at 30 seconds of that process, you're going to come to a very, very poor conclusion about what's actually going on inside any deliberative body.
Okay, so what you're asking reporters to do really is trust you. Trust the judicial branch, especially the appellate judicial branch or the jury deliberation process in trial courts. And I guess what I'm wondering is, what more can the judiciary do to instill that sense of trust and confidence? It seems to be missing from the highest court in the land, and perhaps in many of our courts today. What more can be done?
Well, I mean, I would say I'm asking the press to trust us, but trust but verify. You know, ask us questions, read what we write, and talk to the participants about what actually happened. What more can the courts do? I think we can be as transparent as possible in the issuance of our decisions, meaning write fully reasoned decisions. If an important ruling happens in court at a bench conference, then there should be a record made of that can be shared with the press. I don't think there's much that needs to be done in confidence except deliberation. But I think we're already doing a lot of that. I think it's a matter, I mean, the economics of reporting are such that it's very hard. I'm sure people said, yeah, I'd love to just hang out in court for a few days, but my reporting schedule would never allow that. And I understand that. The economics are such that we don't really do that much. But to the extent that you can invest a week or two in hanging around the courthouse and getting to know the judges and getting to know the PIOs and even some of the frequent flyer attorneys who appear, you will find that you have much greater access to a more genuine understanding about what's going on inside the courts.
Mm-hmm. Well, I saw just quickly in the chat someone asking a question about stare decisis and owning up to mistakes. Maybe you could shed some light on whether this Dobbs case could be viewed as the Supreme Court, as it did in Brown versus Board of Education, owning up to a mistake. And but how well has the Supreme Court of the United States communicated that that's what it's doing, and what is the credibility challenge for the court in making that kind of case?
Well, I think part of it is the rhythm of decision making. When you appoint a justice with 3 weeks left in an administration, or however many weeks there were, and then immediately start overruling precedents and sending signals that you want to overrule even recent precedents, that doesn't convey a sense of confidence that it is the law that is triumphing. It conveys a sense of confidence that it is the bent of appointees who are triumphing. And it was not that long ago that we didn't have that sort of politicization on the court. And I see some of the questions in chat that I will get to in just a second, but I want to point out that Roe v. Wade was a 7-2 decision. Both the majority and the dissent were bipartisan if you look at the party affiliations of the presidents who appointed those justices. But Roe v. Wade was a bit of an outlier in itself. And as I said earlier, it would be very easy. I am a pro-choice person from a personal bent, I will acknowledge, but I could have easily written a brief that sought the overruling of Roe because Roe had a lot of flaws from a constitutional methodology standpoint. So does Dobbs. So when I say until the status quo is no longer tenable, Brown v. Board of Education is a good example. In 1890, we had Plessy v. Ferguson, which established separate but equal. In 1954, that doctrine was effectively cast aside by Brown v. Board of Education. That was a 9-0 opinion. Justices from across the spectrum agreed. And that's what used to happen. Sure, we had dissents. Sure, we had 5-4 decisions, but they were not red and blue 5-4 decisions. They were decisions by justices who had genuine convictions about their analytical framework for the law, not the results. And a good judge, I would submit, doesn't care who wins. A good judge is led to who wins. And I've been privileged enough to work on a court that has been populated sometimes evenly Democrat-Republican, sometimes as now overwhelmingly Republican, and the overwhelming majority of those judges from either party know how to leave that stuff in the parking lot and go do their jobs and work well together, which is why on my court, something like 98 to 99% of our decisions are unanimous. And that's a very telling thing about a court. You often hear people in politics say, we need more dissents. We need judges disagreeing more. That's hogwash. We need judges to trust one another enough to persuade one another that if there's something somebody disagrees with, maybe there's a reason for that, and decide cases as narrowly as possible to get unanimous results. That is the ethos of the Arizona Court of Appeals, and I wish it were the ethos of other courts as well. Unfortunately, the Supreme Court, I'm afraid, has gone completely off the rails and has become a partisan body. So there are times when stare decisis is not an all-commanding principle. For example, judges on an appellate court, take my court or the Third Circuit or state or federal appellate court, are not bound to follow the decisions of their own court. That is part of stare decisis, and that is something that the public largely doesn't understand, that you are not bound by your own court's decisions. Now, when it comes to the U.S. Supreme Court, there are times every several decades where the viability of a constitutional concept in society gets revisited. And you could argue that that's just what happened in Dobbs. But the right to choose is not necessarily about societal functioning the way segregation is. The right to choose is about personal privacy, and both judges and scholars have struggled forever with the question whether there is a right to privacy in the Constitution. When they decide that there is, they have written it in a way that is troublesome because it can't be universally applied. And beware of any legal philosophy that sounds universal. Textualism, for example. We all hear about, well, let's be faithful to the text of the Constitution. Okay, but it was the textualists who came up with 27 exceptions to the warrant requirement in the Fourth Amendment that aren't written in the Constitution. All of us would agree that the First Amendment, which is written in absolute terms, Congress shall make no law, does not protect child pornography. So we can't just say we are textualists, we are originalists. That is, when you hear that, raise an eyebrow. That is cover for a result-oriented decision. And I don't know if that answers your question, but I just want to point out, somebody pointed out, yes, editorial rooms are not public bodies. That's true. I'm not saying the courts are unique or the courts deserve any special protection over anyone else. I'm just saying that the courts are populated, for better or worse, with humans, and humans perform best in certain environments. And sometimes you need to go in the back room and figure things out. But as you're gathering the information, none of us should be receiving information that the public doesn't have full access to. But as we interpret that information, none of us are Albert Einstein every day of the week. Some of us make mistakes, and we have to feel free enough to make mistakes that we can correct them and not become wedded to positions that we may later regret. That's all I'm saying.
So if we're going to address this problem of disinformation, and if we're going to do that, at least in part, by enhancing the public's confidence in the courts and trust in the media, maybe we can agree on a few principles, guiding principles. Can we agree that transparency enhances public confidence and trust?
Absolutely.
And yet we could probably agree that transparency can't be absolute.
It can be pretty darn close. Then
I want to see your deliberations. I want to come
why?
to conclusions.
You know what? You'd be very disappointed. What we do is we circulate drafts on SharePoint. And we comment on them. I'm not sure whether our public access rules would allow access to our SharePoint comments, but they might. When we get into conference, we are fairly rarely doing the kinds of things or having the kinds of conversations that you'd even want to report on. What you'd want to report on, and what people got the chance to this year, is look at a draft decision and see how it changes. That might be interesting, but it's ultimately not very helpful. If I get a fact wrong in a draft and somebody points that out, I'm going to fix it. And it doesn't really do the public much good to say, Swann thought the car was red when it was actually blue, and then he fixed it. Well, so what? I mean, the question is, how did the case come out, and why did it come out that way? Are we following the law, and are we listening to the facts?
So I guess, operating in the digital age, which, as you know, is a challenge for me, but presumably not for so many of the others on this in this conversation at this conference. I wonder whether we could enhance trust, confidence, diminish disinformation by doing something that we can now do electronically in our work that we really couldn't do in a print product, or for that matter, with a broadcast product, and that is show our work. And can the press and the courts do a better job capitalizing on digital communications to show their readers, this is the document that we relied on. This
Absolutely.
is the process that we followed. Would that help?
Absolutely. And that's something that is easily done in many jurisdictions. I'll take Arizona, for example. Everything we do, every decision we issue, no matter how trivial, if it's granting a motion for continuance or deciding a constitutional issue, is online and linkable. So, and you can link to the entire docket in a case with a single link. So publish that link and let people peruse for themselves. Let people see what's actually being argued, what's actually being decided, why there are delays, why the court.
Pardon me for interrupting, but how about the documents referenced in one of your opinions? Just as reporters could allow readers to link to primary source material referenced in their stories.
We are doing that in Arizona right now, and I am working on a case management system that will have every fact in every appellate decision hyperlinked to the specific page in the record from which it comes, and that will be publicly accessible. Now, that is a very painful process that has taken years longer than we had hoped, just for the technological reasons, and there was this disruption a couple of years ago, you may remember, in society. But we are taking measures to do exactly that. Every piece of evidence, every piece of the record that a court relies on is already something that the public is entitled to see, but there's no room for practical obscurity in that world. When it comes to information upon which a court relies, you should be able to get to it with a single click, and that's what we're doing.
You know, let's talk for just a moment about that elephant in the room. I haven't been back to the Supreme Court for an argument since before the pandemic. But in reading about the AP's story, asking the Supreme Court about its leak investigation, I was reminded that the Supreme Court building has been closed to the public for now 2.5 years. Are any of the emergency protocols that the judiciary have adopted creating an environment that invites secrecy in ways that are destructive to our democracy? How open, I mean, the physical manifestation of justice in this country is that Supreme Court building, and the public can't enter. Do we have a problem?
Well, you know, you've caught me on an area in which I'm a little uninformed, because I've given up trying to watch U.S. Supreme Court arguments. I would say the courts in general during the pandemic moved a lot to virtual arguments, virtual proceedings, virtual trials, and that actually, that I think diminished the quality of justice, because we don't do as good a job when we're staring at a screen, but it enhanced public access because every single proceeding was something anybody could just join and watch. And I don't know that that's true in all jurisdictions, but it certainly was in ours. And making, having a video feed for everything that happens except appellate deliberations and jury deliberations, I think is a wonderful idea.
But do you sense that there's been a sort of a gap there between lip and cup when it comes to recognizing the press's First Amendment right to attend, in particular, criminal proceedings? I have found a number of journalists saying, wait a minute, you know, we can't get in, we can't get into the Zoom meeting. What more does the court need to do to recognize that if we're operating under emergency protocols because there's a pandemic, at least some people think there's a pandemic, the World Health Organization, for example, then how do we recognize the media's First Amendment right to attend these vital proceedings?
Well, I would say that it was actually a Herculean effort that let the courts function at all virtually. And the fact that we've been able to let people in is one of the few areas in which we really performed well during the pandemic. We really exceeded expectations. I know it wasn't perfect, but I find it difficult to apologize too much for technical glitches when we switched our mode of operations literally overnight and were successful at it and gave the public access. I do see a couple of comments from people I have apparently rankled in the audience, and I would just like to address a couple of those. How about Supreme Court packing? Now that's going completely off the rails. I couldn't agree with you more. Supreme Court packing is a terrible idea. All it does is dilute the voice of any single justice and kick the can down the road until the next party takes over and has a disproportionate majority. What we need to address is the politicization of the court generally. And the Supreme Court would do well, I would suggest, to adopt a code of ethics for itself, much like the one that it imposes on the lower courts, and much like the one that we all live under in state courts, where we are specifically forbidden from bringing politics into our decisions, and where most judges of both parties, I should say, do an excellent job of avoiding just that. Unfortunately, the Supreme Court has no such ethical code. And I mean, you watch it play out right now with the Thomases. It would be unthinkable for a state court judge to advocate in those ways and retain his or her seat. Go ahead, David.
No, I was just, the thing that I wanted to raise is this. Up until very, very recently, during this time of hyper-politicization on the bench, justices like Stephen Breyer or Justice Kagan, etc., have gone out of their way to say how it's not a political body, how we get together, we get along, we leave our political views at the courthouse step, then we come in and we just do justice. What's the difference between what the Justice Breyers of the world are saying and what you're saying that leaves all of us kind of scratching our head and saying, well, if that's so, where's the trust? It feels like disinformation.
Well, the problem is, court packing in terms of expanding the court, I agree, is a terrible idea, but we've been court packing now for a couple of decades with this notion that presidents, and of course, everybody just focuses on this one court, but presidents should be picking justices who will do what the president stands for. And that's not the constitutional framework. The judiciary is a separate branch of government that is not supposed to do what the president or the Congress wants. The judiciary was created to be an anti-majoritarian government that keeps the law steady through the transitions of political power that are invariably going to sway both ways.
The court branch.
Well, hopefully, the court is really supposed to be that buffer that keeps things stable across the pendulum swings that society naturally goes through. And once the notion that presidents and the Senate are supposed to inject advocacy into the court became acceptable, we started to lose a court that people trust. So yes, that's what I mean by going off the rails. If we announce as judges that we are going to pursue a certain agenda, as Clarence Thomas said, the liberals have made me miserable for 43 years, and I'm going to make their lives miserable for the next 43 years. Dude, we are not supposed to be making anyone's life miserable. We are the last guardians of liberty and the last protectors of the Constitution. We're the only thing that stands between the constitutional democracy and a political oligarchy. If you involve the court in those sorts of political forces, you have lost the benefit of the most brilliantly conceived constitutional model that people have ever come up with.
So now I apologize for putting you on the spot of defender of what has now become this status quo, Judge Swann. However, we've all heard the expression, the Constitution is not a suicide pact. And yet, if we paid attention to that quartet of cases during the last week of the last session of the US Supreme Court, the highest law of the land says Congress can't really regulate climate change. It doesn't have that power. Can't give the EPA the power to deal with global warming. Guns on the street in New York. Sorry, New York, you gotta have guns on the subway. Women, it's sorry, it's no longer, and so on and so on and so forth. At what point does the public say we have to take back our government? And the court is in the way of accomplishing that.
Well, most of the cases you mentioned were actually difficult cases. Yes, they all came out in a direction that favored a certain party, which lends to people questioning whether there are politics involved. It has nothing to do with whether I agree with them or not. And I will tell you all. I see the comment in chat. I don't agree with the results in a lot of the decisions I reach. I do what the law tells me to, whether I like the result or not. Read the only abortion decision I've ever written. And it's very much, yeah.
If I may interrupt, then what else can the judicial branch communicate to the American people through the press about what needs to be done to preserve this little experiment in ordered liberty?
Well, if we're talking about the Constitution, I think it's important to, and this is where the press can help. It's important not just to report on the results, which everybody for certainly the rest of my lifetime is going to assume is political, because that's what it's become. But it doesn't have to be that way. And by the way, most of even the US Supreme Court decisions are decided not by a razor thin majority, but unanimously, because most of them are fairly mundane applications of the law. I think that analyzing not only the label that judges put on their judicial philosophy, but the way they express it to see if it makes sense is the best way. And I know that's a heavy lift for most forms of media, but it can be done. It can be done.
Judge, I'm talking about one slightly different issue, and that is not the Constitution per se.
Okay.
But this situation that we find ourselves in, where judges feel duty bound to interpret the law, which is kind of what I meant about the law being biased toward the preservation of the status quo, in a world that's burning, in a world where we don't have much time to address global warming, in a world where every morning we wake up to another school shooting and New Yorkers no longer can limit guns at Yankee Stadium, for example, so on and so forth. How do respected members of the judiciary communicate to the American people where they can go to fix these problems?
Well, where they can go is the ballot box. I mean, the courts really shouldn't be involved in most of those issues. The court, there is, unless a law commits to the court a decision about global warming, that is an area reserved for the elected branches of government, and people can choose the policies they most favor at the ballot box, and they do. One thing we're not lacking for these days is voter turnout. So that's at least something. It's important to remember, and it's very hard to remember these days because the courts or the Supreme Court is honoring it less and less. It's important to remember the limited role of the judiciary in policy making. We are not policy makers. So when the court says Congress doesn't have the power to delegate decision making about global warming, I admit I have not read that decision word for word, and it may actually have quite a lot of merit, whatever your views on global warming are. Well, I mean, you can say that, but the scope of congressional authority under the Commerce Clause and the enumerated powers in the Constitution is sketchy, and it was deliberately made sketchy. So it is not inappropriate for judges to take different positions on that issue. It is not inappropriate for judges to say there is no right to abortion in the Constitution. It is not inappropriate to interpret the Constitution in ways that are very deferential to the elected branches of government, and in ways that say, hey, wait a second, this Constitution only has a few enumerated powers and there's not much you can do with it. Both of those are legitimate schools of thought. And I'm not going to say that the court has gone off the rails because it goes one way or another on those. What's important is that it be intellectually honest about why it's doing what it's doing, because it is very possible with intellectual honesty to come out either way.
David, I hate to interrupt. This is an amazing conversation. Your Honor, I so appreciate this. But we've been going since 8:30 in the morning, and we've actually had some people on at 8:30 from California. So I thank everybody for joining us. And I may reach back out to you so we can continue this conversation. But this has been a terrific, program that the two of you have put together. And thank you very much for joining PMC, and thank everybody for joining us. And we will have this program available on recording, I think on our website, but I'm going to circulate it to everybody to let them know. So thank you very much.
All right, thanks. Bye-bye.
Have a
Thank
great
you.
day.
Bye-bye. Bye.